your latest permission, may I mention one matter from the Honorable Court number 14 that is listed today at serial number 100 edition. The writ has been filed for setting aside the final merit list of the exam conducted by JPSC for appointment of food safety officers. While the final merit list dated 29th of March 2026. Urgency is that your jurisdiction, in the meantime, appointment letters have been distributed to the candidates. Yes. No, you.
Serial number 145, 14, first of July. Matter is enhancement of age of superannuation.
Enhancement of age of superannuation. There are circulars.
In the board meeting, the age of superannuation is 62, 65, petition is 62. Petition is about 60 years ago. So in 21st of July. And in board meeting, there is a relation past is 62 to 65 years.
Effective from this date.
Serial number 147.
It touches from the other side.
Yes,
Your Lordship, in my matter,
From supplementary list for admission item 1, criminal appeal 247 of 2026.
Anticipatory bail. So I'll take your attention straight to the FIR, which starts at page number 60. May I please read it? सेवा में खाना प्रभारी महोदय कोलकाता रांची विषय आदिवासी परिवार से संबंधित को बढ़ाने की नीयत से मूल एवं नदी गाली देने एवं प्रताड़ित करने के संबंध महाशय वे यमुना गाड़ी पति शैलेंद्र ग्राम सचिन सदर थाना गोंदा जिला रांची झारखंड की रहने वाली राव जनजाति की महिला हूँ। मैं एवं मेरे पति दोनों मेहनत कर जमीन एवं घर कर्ज लेकर बनाए हैं, जिसका खाता नंबर इतना, संख्या इतना, प्लॉट नंबर इतना रखा है। हमारे जमीन के पीछे जो जमीन देकर 15 तल्ला फ्लैट बनवाए हैं, जो अपने फ्लैट के चौदीवारी हमारे घर से सटाकर बनाया है एवं इतना गहरा नींव खोदा जिसके चलते मेरे 3 रूम का दीवार पूरी तरह से फट गया, जबकि हम बराबर कहते हैं इनको कि ठीक से मरम्मत करा दीजिए एवं ऊपर 3 रूम बनवा दीजिए। जब तक उनका कंस्ट्रक्शन चलता रहा, प्याज की भाषा भाभी कहते थे एवं हमारी पत्नी वो घर की मरम्मत एवं ऊपर 3 रूम बनाने की बात कहा करते। जब उनका पूरा फ्लैट का निर्माण हो गया, तब वे चुप्पी साधा। दिनांक 6/25 को जब हम उनको कहा कि आपका सारा काम अब तो हो गया है, अब कब हमारा 3 रूम का निर्माण करेंगे, इतना कहना था कि गाली गलौज करने लगे एवं बोले कि भागो नहीं तो जान से मार देंगे एवं पूर्व आदिवासी को इतना हिम्मत कैसे हुई। गाली गलौज देकर कहे कि अभी भागो नहीं तो अभी मार डालेंगे, तुम्हारा निर्माण में नहीं करूंगा, हम तुम लोग का जमीन हमको छीनकर उसमें भी फ्लैट बनाना है। उसी समय हमारे घर में अंजनी कुमार पांडे भी थे, जो उस व्यक्ति की गाली गलौज अभद्र भाषा का प्रयोग सुना। मैं अपने घर के दरवाजे बंद करके चुप हो गई। अतः जमीन से अगर श्रीमान से नम्र निवेदन है कि फ्लैट सच के मालिक, जिसका नाम अजहर उर्फ रिजवान अहमद पिता सच है, yes, the 3 issues based on this FIR, the sections which has been registered. The first being 324(5) of BNS, 351(2) of BNS, and 31R and S of SC/ST Act. Now, before I take your lordship to what has actually happened, certain facts will be narrated.
See, this anticipatory is not maintained.
I will come to that, how it is maintainable leadership. Now, in order to sustain 31R and S, public view is mandatory. Now, may kindly have your lordship 31R and 31S. 31R.
Yes, the law is well set in
Public view. This entire dispute happened inside the house. There was no public view first.
No, somebody was also there.
somebody that was person who was there was a person who they claim to be there. Now my argument would be, first, this was entirely a civil dispute. A construction happened. Because of me, they claim that some damages have been done. I was called in the police station. I went and I reported to the police station twice in December 2025 and January 2025. Now what happens that they say कि आपका civil dispute है, आप जो damage किए हैं करा, पर उसको ठीक करा. Now we have annexed all the pictures stating that whatever damage was done from our end, we rectified it. We did the entire painting, your ladyship, if your ladyship is willing to see, we have done, and this is an admitted fact which the victim herself admits that all the damages have been rectified. However, now she claims 3 extra rooms should be constructed on my buildings. To that I oppose that the damage that I did, I have done that. 3 extra rooms that you are claiming is not within my purview, and I should not be. The entire civil dispute was as such in nature. Now what happens, your ladyship? They called for the case diary. When the case diary was called, why this matter is listed here today? The victim is the relative of a DYSP. An entire thing was orchestrated on the behest of the DYSP, who influenced the police machinery to arm twist me and to get a work done, a civil dispute, to get it done. Now, once I've already rectified my damage that I have already done, and they are asking me to construct 3 more rooms, to which I denied. Purposely, this FIR was lodged in narrating an incident which took place inside the house. There is no public view as such. Yesterday, when the IU was questioned that whether a DYSP stays there in the house of the victim or not, he blatantly lied. But when the victim's counsel was asked, she said yes, the DYSP resides. The Honorable Coordinate Bench reprimanded the conduct of the IU. He went to the extent of saying that you have the audacity to lie before a High Court judge. The entire...
I don't find it in the record. Please don't.
Yes, no, Lord. Why it is listed today, that is why I'm saying.
He recused. Simply.
He recused for the reason. I'll just
No, whatever be the reason, we are not bothered about the reason.
Ladies and
Because it is not there in the order sheet, I will not accept it.
As your ladyship may please, my only contention is that the entire incident took place not in public.
It was in public. You, in a real statement, she said that, okay, firstly, पूरी घटना के साक्षी बने, प्लीज आगे बढ़कर गाली गलौज देखते हैं कि क्रम में इनका पड़ोसी अंजनी कुमार पांडे वहां उपस्थित थे जो पूरी घटना के साक्षी.
No, your lordship may kindly have judgment which says a person who remains there vis-a-vis a public view. Allow me then, your lordship, to place to judgment which says that public view and view of public are 2 distinct things. May lordship may kindly, ladyship may kindly allow me to place your judgment. Public view and view of public. The main judgment is Hitesh Verma, but this judgment starts from paragraph 9. Paragraph 9. A perusal of section 3(1)(r) of the SC/ST Act would reveal that for constituting an offence thereunder, it has to be established that the accused intentionally insults or intimidates with the intent to humiliate a member of scheduled caste or scheduled tribe in any place within public view. Similarly, for constitution an offence under section 3(1)(s) of SC/ST Act, it will be necessary that the accused abuses any member of the scheduled caste or scheduled tribe by caste name in any place within public view. The term any place within public view initially came up for consideration before this court in the case of Swaran Singh versus State Standing Council. This court in the case of Hitesh Verma versus State of Uttarakhand referred to Swaran Singh and reiterated the legal position there. Another key ingredient of the provision is insult or intimidation in any place within public view. What is to be regarded as place in public view had come up for consideration before this court in the judgment reporting Swaran Singh versus State such as. The court had drawn distinction between the expression public place and in any place within public view. It was held that if an offence is committed outside the building, example in a lawn outside the house and the lawn can be seen by someone from the road or lane outside the boundary wall, then the lawn would certainly be a place within public view. On the contrary, if the remark is made inside a building, but some members of the public area are there, not merely friends or relatives, then it would not be an offense since it is not in public. This sentence appears to be contrary to the what stated below in the extract from Shaban Singh Hutchison and in the application of principle in para 15 below. Also, even if the remark is made inside a building, but some members of the public are there, not merely relatives of friends, they also would be an offense since it is in the public view. The court has held as it is. It has been alleged in the FIR that Vinod Daga, the first informant, was insulted by applicants number 2 and 3 by calling him Joe when he stood near the car which was parked at the gate of the premises. In our opinion, this was certainly a place within public view, since the gate of the house is certainly a place within public view. It would have been a different matter had the alleged offence been committed inside a building and also was not in public. However, if the offence is committed outside the building, for example, the lawn outside the house and the lawn can be seen by someone from the road or lane outside boundary wall, the lawn would certainly be a place within public view. Also, even the remark is made inside a building where some members of the public are there, not very relatives or friends, can also be an offence since it is in public view. We must therefore not confuse the expression place within public view with the expression public place. A place can be a private place but yet within the public view. On the other hand, a public place would ordinarily mean a place which is owned or leased by the government or the municipality or other local bodies or grounds of hub or an instrumentality of the state and not by private person or private bodies. It could thus be seen that to be a place within public view, the place should be open where a member of the public can witness or hear the utterance made by the accused to the victim. If the alleged offence takes place within the four corners of the wall, where members of the public are not present, then it cannot be said that it is taking place within public view. If we take the government's allegation, so thereafter it contains the allegation of facts of this case. So my humble submission is that this entire incident took place inside the house where a friend was standing, and she only claims that that one person was there.
From where do you see that it happened inside the house?
घर के अंदर भी लोग FIR में लिखा हुआ उसी समय 17 पारा 17 उसी समय घर में
नहीं ऐसा
हाँ।
सिलेक्टिवली
तब फिर से पूरा FIR पढ़ते हैं लेकिन आज इस केस जब उनका पूरा फ्लैट मेरा इंटायर FIR हो गया
6 तारीख को 6 तारीख 6 only 6 that is the date of the incident.
Yes, you know, petition.
जब उनका फ्लैट का निर्माण हो गया तब ये चुप्पी साझी दिनांक 6/3/25 जी
Reading the case
no I'm reading the FIR
FIR हाँ दिनांक 6/3/25 को जब हम उनके घर हमने उनको कहा कि आपका सारा काम अब तो हो गया है, अब कब हमारा तीनों रूम का निर्माण करेंगे, इतना कहना था कि गाली गलौज करने लगे एवं बोले कि भागो नहीं तो जान से मार दो एवं गोरखपुर आदिवासी को इतना हिम्मत कैसे हो गया गाली गलौज देकर कहने अरे भागो नहीं तो अभी मार देंगे तुम्हारा निर्माण हम इसमें
कहाँ लिखा है
आगे देखो आगे लिखा जाए
उसके बाद हम घर बंद कर
नहीं उसी समय हमारे घर में उसी समय ठीक है और आगे भी देखेंगे पूरा आगे बढ़े उसी समय हमारे घर में अंजनी कुमार पांडे जो थे जो उस व्यक्ति को गाली गलौज अभद्र भाषा का प्रयोग सुना मैं अपने घर में दरवाजे
नहीं the incident is not clear it is not that the incident this particular incident had taken place inside the
leadership the FIR needed to disclose I'm just submitting leadership
she went
no that has not come in the case diary also that she had gone to that building it has not come in the case diary it has not come in the investigation the case diary was called your leadership the case diary doesn't disclose that she has gone outside or she has gone to the 15-story building which was being constructed this entire incident in the case
does
diary
it say that the petitioner came to her house
yes your leadership it does not say she said in the case diary
from where are you reading that the petitioner came to her house
but in the FIR it is said that the entire incident took place in the house
you see
and it is
just a moment from where you say from
in leadership, it has come that she,
It has come.
in the case diary,
May I say something about this? In the restatement, she had stated, आगे बताइए दिनांक 6 दिन को ये अजहर और रिजवान से भेंट की
कहाँ में?
और बोली क्या आपका सब कहाँ पे भेंट की लेकिन ये घर के अंदर भेंट की ऐसा नहीं बोला
एक second.
and there is this particular person
Is a friend.
Anjani Kumar
Is a friend, and that is what the Supreme Court judgment says, your leadership. Not merely presence of a friend or relative. And I'm only trying to say, your leadership, that in the FIR, has she ever stated that हमको इतने लोगों के सामने मिला? In the cases like this,
लोगों के सामने बोलने की जरूरत नहीं है लॉ में खड़े होकर बोल दिया तो भी काफी
लॉ तो ये सीधा लिखे हैं, घर में पब्लिक व्यू है ही नहीं leadership. May kindly see, this is not a place of public view, your leadership. And your leadership, may I submit one thing? Case of civil dispute where I have already is it not an admitted fact that I have already rectified the damages?
for your regular bail, of course, these things can be considered. But in view of Section 18 of the SC/ST Act,
Public view is mandatory, your leadership. Public view is
I
mandatory.
cannot hold that it was not in public view.
Where is it in the FIR, leadership, that it is in the public view, leadership?
No,
Prima
it is
facie,
not
it is just stated that मेरे घर में
मेरे घर में आए ऐसा कुछ है ही नहीं.
मेरे घर में
It is not there.
मेरे घर में उस वक्त अंजलि घर में
Anjani Kumar had said that he had approached them, right? And then he saw that this was happening.
घर में your leadership, may kindly hold on this entire incident, and उसके बाद निवेदन उसमें नीचे भी लिखा हो. May kindly take my submission to leadership that entire incident happened. I am submitting it's inside the, even in the case diary it has not come, it's in the public view. Your leadership case diary में भी कहीं नहीं लिखा कि public view में हुआ. In the entire investigation.
There are witnesses, your lordship. 3 witnesses are there who have said that they have seen the occurrence and they have.
Where they have seen the occurrence?
Where are those witnesses? Refer to those. Your lordship, one is this Anjani Kumar Pandey. Yes, your lordship. He said that he has seen. And Lakshmi Devi. She is the wife of Santu Lohar. She had stated that, your lordship. Yes. जब यमुना गढ़ी के घर की ओर से शोरगुल सुनाई दे रही थी तो ये देखने गई तो देखी कि यमुना गढ़ी को अजहर और रिजवान अहमद जान से मरवा देने की धमकी देते हुए कह रहा था तुम सचन सच उसके बाद गाली वाली बातें हैं your lordship. And second is Anjani Kumar Pandey. He had also supported. Then he has seen the occurrence, your lordship. And third is Jitendra Ura. He had also stated that he has seen the occurrence, your lordship. जब यमुना गाड़ी जितेंद्र उरा ये स्टेटेड जब यमुना गाड़ी अजहर और रिजवान अहमद को बोली कि आपका फ्लैट का काम हो गया है हमारा मकान का मरम्मत कब होगा इतना ही बोली कि अजहर और रिजवान इस पे हाइपर होकर बात करने लगा तुरंत गाली देते हुए बोला कि तुम सचिन सर सबको हिम्मत बढ़ गया है जाति सूचक गाली देते हो. There are 3 witnesses here. You have seen the
This application has been filed against the order dated 17/2026 passed in the number 60 of 2026 by the National Commissioner from the Special SC/ST Action, whereby the anticipated bail application filed by Rahul Gandhi in relation with Punjab case number 68 of 2025 for offence punishable under section 324 351 of BNS and section 3 I then bracket R/S of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act has been rejected. The counsel for the Appeal submitted that one of the prime consideration for rejection of anticipated bail by the lower court is bar under section 18 of the SC/ST Act. The legal counsel submits that the entire incident had taken place inside the house of the informant, and For that purpose, she has placed the FIR and has submitted that since the incident had taken place inside the house, the basic ingredient for commission of offence under the SC/ST Act is not satisfied. She has referred to section 3 within bracket R and S of the SC/ST Act and has submitted that the offence under the same act has to be committed in any place within public view. She has referred to the judgment passed by the Supreme Court reported in 2025 SC19 SC215 and has submitted that and has referred to paragraph 9 and 10 of the state judgment and has submitted that once the alleged incident had taken place inside the house, the aforesaid sections are not impacted, and therefore the bar under section 18 of SC/ST Act is not implemented. And so far as the other allegations are concerned, the informant has been insisting upon the petitioner, upon the appellant, that since their house was damaged on account of the construction undertaken by the appellant, therefore the same was required to be repaired, and further 3 rooms on the top was also required to be constructed. She submits that amounts to extortion. The appellant does not have any obligation to get any construction done. The for the informant case. The learned council has also submitted that the damage to the house which was of the informant which occurred on account of the construction activity undertaken by the appellant was also rectified. A counter affidavit has been filed on behalf of the informant, although the counsel for the informant is not present before this court. Wherein it has been stated that it was falsely stated by the appellant that rupees 3,000 was paid as compensation. The Learned Council for the state has proposed a prayer for bail and has submitted that in the face of the FIR, it does not mean that the incident had taken place inside.
This is 7, 8, and 9 paragraph.
She has referred to paragraphs 7, 8, and 9 of the case diagram and has submitted that 3 witnesses have supported the case of the prosecution, and they have stated that they had seen the evidence and they have stated that the applicant on 3/6/2025 had uttered the words, uttered words in caste name within bracket Adivasi, Haramzadi, and Gawar. And has insulted the informant in caste name. When it comes to some extent, the witnesses having seen the evidence, so there can be no doubt that it was a commitment, and thus the learned court has rightly held that the anticipatory bail was not maintained on account of bar and section 18 of the CST. After hearing the learned counsel for the parties and upon ruling to the FIR, it appears that some construction work was going on besides the house of the informant and was being undertaken by the applicant, and the house of the informant suffered certain damages on account of the construction. And as per the FIR, the applicant has been assuring the informant that he would get the repair work done. And further appears that as per the FIR itself, the informant was insisting that 3 rooms be constructed, and to which the applicant initially agreed. However, after the construction work was over, on 6/3/2025, when the informant asked the applicant as to when the construction work will be done, it is alleged in the FIR that the applicant abused the informant in caste name and asked the informant to leave immediately. And as per the FIR, during the incident, one Anjali Kumar Pandey had also come, and he had witnessed the entire incident. This diary reveals that as many as 3 witnesses have stated that they had witnessed the incident. In such circumstances, the argument of the counsel for the applicant that the entire incident had not taken place in public view is not acceptable. Further, the learned court has also considered the materials and has referred to section 18 of the SC/ST Act, indicating that anticipatory bail is not maintainable. This court is of the considered view that, considering the nature of allegation, it was said to have been witnessed by not less than 3 witnesses, which has come in witness diary. The anticipatory bail filed by the applicant was not maintainable. Probably this is dismissed.
Item 2 BA 5021 of 2026 along with item 3 to 5.
This is due to personal difficulty, Mr. Rahul Vijay. So, her mother leg was fractured in children 2, 3, 4, 5, 6. After every criteria.
The learning council. 2, 3, 4, 5, 6.
Yes, and maybe
The learning council with the petitioner seeks adjournment on account of person in the learning council meeting, Mr. Rahul Ranjan. But then the next thing we need to go to just a minute.
daily list 11:23.
एक हफ्ता लेके नहीं लूंगा और ज्यादा टाइम चाहिए you need more time next Wednesday next Wednesday कौन सा date है फिर तो बहुत व्यस्त है नहीं हो सकता 8 August और बताइए और कौन सा
Daily 11:23, 26, 27, 23.
लेकिन सबके साथ औरों का भी तो केस हुआ नहीं सभी का सब एजेंडा because lot of these cases are ongoing.
Only 10 cases.
Sir, independent cases है it is tied up with other cases.
No, tied up नहीं है already.
11
23.
एक second. 11
23.
23 तो with
With 22.
ऐसे नहीं करेंगे ना 23 और
26, 27.
नहीं केस कॉल ऑफ नहीं है सबके साथ लगा हुआ है ऐसे कैसे आपको रहना होगा आप देखिए
Supplementary ladies.
सप्लीमेंट्री तो सारा है उसको तो सब नहीं का नाम
In 11 daily.
From daily list for admission item 1 BA 4178 of 2026.
Lordship, Sagar case. Prosecution case is that Lordship, branch manager of the bank, Bank of Baroda found some unusual transaction in the account and informed the police and the cyber police registered this case, Lordship. My involvement is that only, Lordship, for 15,000 rupees I have opened bank accounts.
of different persons
Lordship,
for 50,000 or 50
15,000.
50,000
500 का ट्रेलर में थी
हाँ?
उसमें अभी फुट नंबर 13
Lordship, for last 5 occasions, this APP is not appearing properly, assisting the court. कभी उनका फाइल भुला जाता है, कभी फाइल रिकंस्ट्रक्ट कर रहे हैं for last 5 occasions. कभी वो कोर्ट में अभी 2 मिनट पहले थे, अभी हट गए. And for his inefficiency, I am languishing in jail. For last 5 occasions, he is taking adjournment.
हाँ अभी फुट 13 में
अभी थे यहाँ बैठे
एक
हुए.
बात बताइए हम लोग को सर्कुलर आया है कि मिस्टर सलीम कुमार तिवारी हैज बीन allocated this court right फिर why this circular has come to us why this circular has come to us
दो केस के लिए 500 का
ये हमको समझाइए ना इस चीज को ये सर्कुलर क्यों भेजे हैं एजी साहब उन्हीं को बुलाइए उन्हीं से पूछते हैं कि जिनको आपने इस केस के लिए इस कोर्ट के लिए allocate किया is not there he is moving in different courts so you should withdraw this circular why should we bother about this circular आप एजी साहब को बुलाइए क्योंकि जब उन्होंने हमें लिख के दे दिया है कि he is allocated for this court room he is not there
दो केस के लिए 500
पास ओवर करके क्या करेंगे साहब उन्हीं का केस है आज
बुला रहे
सारा का सारा उन्हीं का केस है बुलाइए उनको और ऐसे कोर्ट करके जाएंगे तो एजी साहब को बुला लेंगे साथ में अब पूछेंगे भाई चिट्ठी किस लिए दी हम लोग सर्कुलर इशू करके व्हाई हैज ही इशूड द सर्कुलर when his officers have no respect for his circular अब जब एक चीज आपको बुलाइए तो ये कहानी ऐसे सॉल्व नहीं होगी. You ask him to come. Basically, ask him to be here.
Item 2, BA 4997 of 2026.
In the case of cyber offense, since the recovery is of one phone with one SIM, and he is having no accident, and so far the statement one victim has claimed that he had reported the sum of rupees 699, chased in number rupees. Same co-accused has been granted.
The Lemon Township Public Service that once Singham mobile is alleged to have been recovered from the possession of the petitioner, and the petitioner has no criminal activity. Only one victim
That is 699.
for an amount of rupees 699 has been identified.
That is it.
He also submits that another confused namely Sujal Ansari, who also had no criminal antecedent. He has been enlarged on bail in BA number 3716 of 2026.
I have 17 rankings.
And
No antecedent.
the para 7, क्या बोलते हैं?
इसमें specific counter file हुआ है.
Para 7 में क्या बोलते हैं?
And 7 of
Of counter.
that is from confession. The confession.
The second counter has been filed. They have brought the report matters. Or the
I have
report
filed
is
supplementary.
counter.
आप para 7 में क्या बोले हैं supplementary counter?
Yes, madam. I have announced also 17 crimes and 4 victims जो complaint की NCRT portal पे
Four
FIR
4 victims है ना, 1 victim तो नहीं है. How many victims are there?
डायरी में नहीं बाद में वेरीफाई किए हैं 4 victims आया जो कि एसपी
4 victim आए हैं ना, और ये 1 antecedent भी है.
one antecedent in the confession is
Para 7
it's not in confession.
he stated so in his confession statement.
Yes, madam. It has come in a diary.
So the second counter has been filed. They have stated that apart from this case, no case is against the
It
very
has to do 1 week.
And there are 17 crimes of
17
different
crimes.
states.
Yes.
The co-accused was who has been granted bail. He was also having rankings, but no case was also registered against him.
The counsel for the state has submitted that as many as 17 crimes were found against the petitioner relating to different states, and 4 victims have been identified, and there are 4 victims who are made complete online on NCRT.
Statement of one victim. And chart is the second counter that is by page 6 is the second counter ka page 6. The third line.
Page 25. सिम और वो किसके नाम से?
Now, सिम हमारे नाम पे नहीं था. co-accused को जो बिल हुआ उनका भी सिम उनके नाम पे नहीं था. That is also there. उनके सौरभ के नाम पे था. और पेज 6 में एंटीसीडेंट के बारे में है सेकंड काउंटर में थर्ड लाइन दास कितना से सभी देवर के विरुद्ध इस कांड के अलावा अन्य कोई कांड नहीं पाया. That they have brought by the statement. the LDC has raised this to file second counter affidavit. They have brought.
After hearing the learning comes before the parties. And considering the fact that the petitioner has no criminal antecedent as per the prompt affidavit. And similarly, security produced namely Sufya and Sati has been enlarged on both.
And one more co-accused, that is in the para 2 last.
Petitioner is likely to be enlarged. Judgment of one.
चार्ज शीट पे एग्जाम हो गया
Charge sheet. 3626. Charge sheet having 7136. इसका कोई कॉन्फ्रेंस तो आप लोग देंगे
हाँ एक
सीरियल नंबर
नहीं आज नहीं
आज नहीं है
थैंक यू ये एक ही
Item 3, BA 5075 of 2026.
It's a case of cyber offense. The recovery is of one phone with two SIM. He is having one antecedent of similar in nature. That too, and his facilities.
one mobile
Two SIM.
one
One antecedent similar in nature, on which he is on bail. And the custody is of 5th of April 2025. And charge sheet has been submitted on 18th of July.
One meeting.
And
one victim has been identified.
Yes, sure. And there is also
Amount
the FIR was lodged against this only because he is only one case.
creation of several e-wallets and use of those SIM cards.
That is the allegation.
That is
Against only one accused person, the FIR
amount
has been.
571,800.
While holding a process of reading the law, also for the petition means that the petitioner is in custody since 25/4/2026. One mobile and two SIM are alleged to have been recovered from the possession of standing in the name of the three persons. Standing in the name of the three persons. Is that accept? Charge sheet has been submitted.
Yes.
The petitioner may be enlarged. The learned counsel for the state by refusing the failure to agree assumptive that the petitioner has one criminal antecedent of similar nature and one victim has also been identified. It is the case against the petitioner is that several e-wallets with for and improper use of forged SIM cards and multiple numbers have been found associated with the seized mobile device, to which the petitioner has made no explanation. After hearing the legal counsel for the parties and considering the allegations and mobile and SIM recovered from his possession, to which he has no explanation, in which several e-wallets and use of forged SIM cards were found. And the petitioner also has one criminal antecedent. This case is not entirely in the petitioner either the petitioner is therefore big after expiry of 6 months.
Item 4, BA 5114 of 2026.
So the FIR was registered as 103 of DNS. Corresponding to 302 of IPC. And charge sheet has been submitted as 108 of DNS. Corresponding to 306 of IPC. So page 80. निवेदन पूर्वक है कि मैं रेखा देवी उम्र 45 साल पति सज्जन से मेरी पुत्री काजल देवी उम्र 27 साल का विवाह वर्ष 2015 के अप्रैल माह में दिलीप लाल के साथ कृष्ण पिता रेसिडेंसेस के साथ अंगूरी दिवस का जिसमें शादी के बाद से उसके पति सास ससुर एवं देवर मिलकर मेरी बेटी काजल देवी को मायके से पैसे मांग कर लाने के लिए मांग कर बताया करते रहते थे। इसी बीच दो बेटी एवं एक बेटा का जन्म हुआ। इन बच्चियों के भरण पोषण के लिए पैसे और आर्थिक सहायता का दबाव उनसे दिया जाता तथा यह पूरा न होने पर मारपीट एवं गाली गलौज करते थे तथा इनके पति के द्वारा आत्महत्या करने के लिए बार बार मानसिक दबाव दिया जाता। एक माह पूर्व इनके देवर पवन लाल श्रीवास्तव के द्वारा मेरी बेटी को बहुत मारा गया एवं यह कहा गया कि इसे मैं ही मारूंगा। पवन लाल श्रीवास्तव के द्वारा यह कहा जाता कि मेरे भाई दिलीप लाल श्रीवास्तव ने इसे मारने का आदेश दे दिया। दिलीप लाल श्रीवास्तव के द्वारा भी फोन पर मर जाने के लिए दबाव डाला अन्यथा वह खुद उसे मार देगा या मरवा देगा। मुझे पूर्ण विश्वास है कि मेरी बेटी काजल जी कहती है उसके इसके देवर पवन लाल श्रीवास्तव पति दिलीप लाल श्रीवास्तव सास अंबिका देवी ससुर मैं देवर था छोटा भाई मेरी बेटी घटने की जानकारी इसके काजल देवी के पूरे परिवार के संज्ञान में पूर्व से ही थी, परंतु फिर भी इसे रोकने का या बचाने का कोई प्रयास परिवार के सदस्यों द्वारा नहीं किया गया, बल्कि फोन कर पवन लाल श्रीवास्तव ने दिनांक 1/4/2026 को समय 5:30 बजे बताया कि आपकी बेटी आत्महत्या करने जा रही है, जो सरासर गलत है। इसके पूरे परिवार द्वारा पुरानी कहानी से the death has occurred. She has committed suicide after about 11 years of marriage. And at the time of occurrence, the petitioner was at Ghaziabad in a jeans factory. And it has come in the diary also. And the investigation has said from the CCTV footage it has come. This petitioner was 1/4/2026. Same Case 24 of the appeal order, we also find the second paragraph, the finding. Hence, after considering all the facts as well as the case diary, transpired that the offence is very serious in nature. The petitioner has been directly named in this case. Although from the case diary it appears that there is a statement of witnesses that on the date of occurrence the accused was not present, but the victim of crime of suicide of death does not take place. It does not take place only in Jharkhand.
Very much thank you for the informant. I have 3 points. At para 68 of the case diary, the serial and CAF of the petitioner as well as the deceased has been provided, wherein it has clearly been mentioned on the date of occurrence. There was a conversation between both for 11 times. The witnesses have it deposed that the husband used to force him for suicide several times. They are the sisters of the deceased. Para 21, 22, 23 of case report. And 24. They have specifically stated दिलीप लाल श्रीवास्तव के द्वारा फोन पर इनकी बहन को बार बार मर जाने के लिए दबाव डाला जाता था. Also in the inquest report, it is stated कि दाहिने हाथ पर लाल और पीठ पर लाल जैसा निशान. There were injuries already on the body.
State. Other witnesses also have a hospital.
There had been dispute between the district and the PD. Para 11 with
regard to PM report, there is no any injury point. Application mark है.
Inquest report.
Inquest report.
Or the Learning Council Secretary in India. The Learning Council for the Petitioners against the petitioner is by national services, and he has been falsely implicated in this case. The marriage between the petitioner and the deceased had taken place in the month of April 2015. That is 11 years prior to the incident. And it has come during investigation that at the relevant point of time, the petitioner was in Ghaziabad. He says that initially the case was lodged under Section 103 of BNS. However, the charge sheet has been submitted under Section 108 of BNS. The wife of the petitioner had committed suicide while the petition was the Learning Council for the informant as well as the state have proposed a prayer for bail and have submitted that. It has come in the inquest report that there was dry injury found on the body of the deceased, and it has come during investigation that there has been dispute between the petitioner and his wife, and the witnesses have also stated that the petitioner used to instigate his wife to commit suicide, and ultimately she committed suicide. After hearing and they have also stated that as per the FIR,
CDR.
She also submits that as per the CDR report, on the earliest date of incident, there was communication between the petitioner and the victim for 11 times. After hearing the Learning Council for the parties and considering the materials collected during investigation, and also the statement of the witnesses, which indicate that the petitioner used to instigate his wife to commit suicide, and ultimately she committed suicide. This court is not inclined to announce a petition on the
Item 5, BA 5148 of 2026.
One mobile and my 5 paper in the position.
withdrawn the case twice again.
चार्जशीट नहीं हुआ उसके चलते वीडियो किए थे।
दो बार आपकी withdrawn
एक वीडियो के अंदर चार्जशीट नहीं हुआ, दूसरा वीडियो के अंदर ऑर्डर शीट में कस्टडी करा।
कस्टडी कब से आपकी?
कस्टडी 17/2/26। One of the points we have granted will by
You anticipated.
no payment. State of क्राइम लिंक के बारे में तो नहीं आया है। बोलते कि पोर्टल पर 4 कंप्लेंट था जिसमें कोई किसी में एफआईआर नहीं।
तो क्राइम लिंक के बारे में इन्वेस्टिगेशन में नहीं।
One of the points we have granted.
35 laws.
Para 35 में
There are 3 crime link found during the investigation of the panel. All 3 crime link is verified, and
mobile number
complainant has given a statement that they have been cheated also, and police have given the letters to those complained for remand.
My mobile number is my note 870696449998, and my note link wallet mobile number is my note 620 and 34642.
Just a moment.
Not with the
Just a moment. Anuka has written letter for this remand in 2 cases.
Yes.
Page number 7. In Bhimwara BS district, Sirohi, Rajasthan,
and one of Kolkata.
Nagar PS district yes रिमांड के लिए लिख रहे हैं तो केस इंस्टीट्यूट हुआ कभी नहीं लिख रहे हैं
केस में कंप्लेन इंस्टीट्यूट
Complaint
उसमें जो पुलिस स्टेशन का डिस्क्रिप्शन आता है उस पर ये लोग कॉरेस्पॉन्डेंस करते हैं
कॉरेस्पॉन्डेंस करके उनको
That
बोले
is
कि
described.
रिमांड में लिया जाए
अगर इफ रिक्वायर्ड अगर आपको रिमांड लेना तो ये आदमी हमारे यहाँ अरेस्टेड है उसके बारे में कॉरेस्पॉन्डेंस ये दैट इज डिस्क्राइब इन डिटेल इन एनेक्सर ए लॉर्डशिप पेज 10
सस्पेक्टेड क्राइम लिंक्स आर 1026
मेरे बारे में आया 3 कंप्लेन
इनके बारे में 3
आया मैं 4 कंप्लेन बता रहा 4 कंप्लेन जिसमें 3 कंप्लेन है और जिसको कहीं भी बयान नहीं हुआ लिखे लास्ट में लिखे हैं इनके विरुद्ध इस कांड के अलावा कोई कांड दर्ज नहीं पाया लास्ट लाइन में लोग अपराधी के इतिहास
हाउ मेनी विक्टिम्स आर देयर
अरे विक्टिम का स्टेटमेंट
हाउ मेनी विक्टिम्स
2 विक्टिम के बारे में एक विक्टिम बोलते जिसका नाम लेते हैं मेरे मोबाइल से टैली नहीं कर रहा कोई दूसरा राजेश विक्टिम है
So, according to you, there are how many premises? 3.
4 एक जगह 4 है एक जगह 3 है
ये ऊपर गया 3
And victim according to you is 4. How many victims have been identified?
all 4
All.
they have stated that they have been cheated one का अटेम्प्ट सिर्फ हुआ था और 3 का विक्टिम का अमाउंट चीट किया
एक के बारे में पैसा मारा गया
एक का 24,986 रुपया
एक के बारे में आता है
सेकंड का अटेम्प्ट हुआ और
फोटो वायरल किया गया
थर्ड का
36 में दूसरा एक का है जिसमें आया हुआ है मोहित अग्रवाल इनके पास से इनका कोई खाली कंप्लेन है बस
2 का कंप्लेन है 2 का अमाउंट है लॉटरी पे का 90,455 एक का 24,986
मेरे मोबाइल नंबर से टैली नहीं करता सीजर लिस्ट माइनर का लिस्ट माइनर सीजर
किसका कंप्लेंट आपके मोबाइल नंबर से टैली
मेरे मोबाइल नंबर से टैली
किसका कंप्लेंट
दोनों
कौन सा वाला
तीनों का
जी
एक मोबाइल रिकवर हुआ उसका सिम नंबर जो दिया हुआ है वो सिम नंबर से टैली नहीं करता कोई दूसरा नहीं
आपका सीजर बताइए
पहली सिम माइनर सीजर लिस्ट माइनर पेज 27 माय मोबाइल नंबर है 8709644998
पेज 27
हां 27 970 one mobile minor 970 96449998 और माइनर विक्टिम इसमें आया 37 में 6203464217 अदर मोबाइल नंबर में and my other mobile number is same minor 6203464214 and my other melody 93028073707 and my mobile number is my location
क्या होते हैं जब टैली नहीं करते
लॉटरी पारा 35 को देखा जाए और द केस डायरी
मोबाइल नंबर 214
जी
उनके पास से कोई कंपनी नहीं है
जी तो अदर रंजीत मंडल के बारे में
लिखते स्क्रीनशॉट के ऑलरेशन से प्राप्त मोबाइल नंबर का बारी-बारी से जांच एनसीआरपी के पोर्टल पर पता चला कि उक्त अभियुक्त के पास से बरामद सिक्योरिटी और 3 कंप्लेंट दर्ज पाए
ये 214 तो मोबाइल के पास से रिकवर ही नहीं
इसके बाद का पैराग्राफ 36 को पढ़ा जाए उसी में से एक जो कंप्लेन है उसके बारे में डिस्क्राइब करते हैं फर्स्ट कंप्लेन के बारे में कंप्लेन नंबर 2 कंप्लेन नंबर दिया डिटेल समन्वय पोर्टल पर जांच करने पर आया कि शिकायतकर्ता नरेंद्र कुमार मोदी पिंडवाड़ा सिरोही
मोबाइल नंबर नहीं डाली
1.62 नंबर लिखा हुआ है अभियुक्त के द्वारा पीड़ित को मोबाइल नंबर इतना से इनके डेमो व्हाट्सएप नंबर पर भेज के मंगाया गया था। इसके बाद इनके भारतीय स्टेट बैंक का इतना से इतना रुपये कट गया। प्राथमिकी अभियुक्त रंजीत कुमार मंडल अपने खाता बैंक ऑफ बड़ौदा के अकाउंट नंबर में मंगवा लिया।
रंजीत मंडल हम है ही नहीं,
तो रंजीत कुमार मंडल नहीं,
हम तो दूसरा रंजीत मंडल है।
आप कौन है?
दूसरा नंबर तो आईडी मैडम
आपका नाम क्या है?
23 में कंप्लेन हुआ है।
आपका नाम क्या
मेरा
है?
भी रंजीत मंडल है, फादर्स नेम अलग हो सकता है, लेकिन इनका 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 जो है
प्राथमिकी अभियुक्त एक सेकंड, प्राथमिकी अभियुक्त आपके बैंक खाता, ये बैंक खाता आपका है कि किसका है?
मेरा नहीं है।
दिस अकाउंट डज नॉट
ना ना कुछ नहीं है। और पारा 36
एफिडेविट फाइल कर दीजिए कि ये बैंक अकाउंट आपका नहीं है।
दे देते हैं। टीवी एफिडेविट फादर्स नेम वाला फाइल कर देंगे। मैं रंजीत मंडल का फादर्स नेम क्या है और 2023 का कंप्लेन है। पारा
बैंक ऑफ
36
बड़ौदा में आपका अकाउंट नहीं है।
जी नहीं, पारा 36 देखा जाए ना, इसमें 23 का कंप्लेन है। 11/10/23 11/10/23 के बारे में बोलते हैं कि उस समय जो है 1930 पर कंप्लेन किया 2023 में, 2026 का ऑपरेशन।
यस, ये जो खाता पे पैसा लगा रहे हैं, खाता का कुछ है?
नहीं, खाता का डिटेल एनेक्सर नहीं है लॉर्डशिप, ये एनेक्सर इनके पास है। तो डिटेल अगर हम मंगा लेते हैं उसमें सब
फादर्स से भी मंगा लेंगे तो क्लियर हो जाएगा रंजीत मंडल के बारे में। उनके फादर्स नेम क्या है, मेरे फादर्स नेम क्या है। सीजर होगा मोबाइल, एक ही मोबाइल सीज हुआ मोबाइल।
इस केस में एक ही रंजीत मंडल है।
यहाँ पे एक ही रंजीत कुमार मंडल है।
दो रंजीत मंडल है।
और मेरा वो नहीं करना है। ये जो सीजर, ये जो पारा 36 में जो रंजीत मंडल का जो मोबाइल नंबर लिखा हुआ है वो मेरा नहीं है।
During the course of argument, paragraph 36 of the case diary has been referred to, wherein it has been stated that the named accused, namely Ranjit Kumar Mandal, has received defrauded amount in his Bank of Baroda account number 991601001587. The learned counsel says that the bank account does not belong to him, but it belongs to another Ranjit Kumar Mandal, and that can be verified only from the bank consent, right? The learned counsel for the petitioner undertakes to file a supplementary affidavit in this connection. The learned counsel for the state is also directed to file a supplementary affidavit with respect to paragraph 36 of the case.
फादर्स नेम के बारे में भी
Father's name भी बिना नहीं।
दोनों का
The father's, it should reflect the name of the account holder, his father's name should reflect. दो रंजीत कुमार मंडल सेम नाम का है।
एक और हुआ था इस तरह का रिपोर्ट आया कि दोनों अलग, तो हम वहाँ पर जो है वोटर आईडी फाइल कर
दीजिए आपका अकाउंट।
आइटम 1 पासवर्ड बता।
आइटम 1 हाँ, एक पेज पासवर्ड हुआ था। हाँ, बताइए क्या है? आपको ये फोटो एलोकेटेड है ना, फिर आप लोग कहाँ घूमते रहते?
घूम नहीं रहे हो, एक साथ 3-4 जगह। जैसे
नहीं,
13 नंबर में आइटम
हमारे
नंबर
पास एक सर्कुलर आया आज ही AG साहब का कि you are allocated this photo and different persons are been allocated different photos.
ऐसा तो हमको
ऐसा हम लोग के पास आया है।
एक लेटर आया है कि 8-8 10-10 एपीपीस का ग्रुप बना है।
हाँ, ये जरा देखिए इसमें।
और एक्चुअली हम लोग को भी वहां से
ये
इंस्ट्रक्शन
जरा देखिए, just have a look at it. Code number 11 में you are specifically assigned.
इसके अलावा भी मेरा कोड नंबर 4 में भी केस लिस्टेड है।
ये 4 में आपका अलॉटमेंट है?
यस,
4 में कोड नंबर 4 में इस लिस्ट के अनुसार।
नहीं ये लिस्ट दूसरा चीज है। ये पर दिस नहीं इसके अगर हम इस कोर्ट में अपीयर होंगे और हमारे यहाँ पे नॉन अपीयरेंस रिकॉर्ड हो रहा है डीबी में, मेरा एडवर्स रिमार्क हो रहा है 13 नंबर में, इधर है एडवर्स रिमार्क हो रहा है। तो ये लेटर को अगर जो इशू कर दिया, इसको अगर हम फॉलो करें तो डेली एवरेज मेरा 3-4 कोर्ट में एडवर्स रिमार्क। तो हमको ये लेटर दे दे कि यू आर ओनली
क्योंकि कोई और एपीपी अगर खड़ा हो तो स्टाफ तो सवाल पूछेंगे, वो तो बोलिए नेचुरली।
अगर वो हमको बोलते कि आपके सारे अदर कोर्ट से हटा के सिर्फ आपको असाइन किया जाता है उसी को।
लेकिन आई डू नॉट नहीं,
आज के लिस्ट में है लॉर्डशिप, जब आइटम
नहीं,
नंबर
I can understand there may be many cases listed in different courts.
जब आइटम 1 खोल दिया
लेकिन ये फिर सर्कुलर हम लोग को किस दे दिया?
अब ये हम लोग बचा नहीं पा रहे हैं उसको।
इनके केस में क्या है बताइए सीरियल नंबर 1।
सर यही लेटर इशू की है लोग, ये बता देंगे क्या अरेंजमेंट है।
जनरल ऑफिस से इशू हुआ है,
बहुत सारा केस लगा हुआ है, वो आप लोग
जनरल ऑफिस से इशू हुआ है, इसमें क्या
हम लोग ये सब लेटर नहीं मानते क्योंकि इससे
ये तो लॉर्डशिप ये दिया गया है कि इन एब्सेंस ऑफ द कंसर्न एपीपीज जो नहीं रहेंगे या तो टाइम लेंगे या वो आपको, ये हम लोग को इंस्ट्रक्शन दिया हुआ है सारे मेंबर्स ऑफ द डिफरेंट रेस्पेक्टिव कोर्ट्स के जो ग्रुप मेंबर्स हैं, ये जस्ट वी आर रिप्रेजेंटिंग द स्टेट।
जो एपीपी को फाइल है, जो केस तुम्हें काउंटर फाइल कोई दूसरा एपीपी कुछ असिस्ट करने की स्थिति में नहीं, क्योंकि ना तो उसको केस डायरी के बारे में कुछ पता होता है, ना उसको केस के बारे में कुछ पता होता है, या फिर ऑर्नामेंटल अपीयरेंस चलेगा।
या ऑर्नामेंटल अफेयर्स की बात नहीं हुई, इसमें यह है कि अगर कंसर्न एपीपी नहीं है, किसी दूसरे कोर्ट पे चले गए हैं तो टाइम लेंगे, टाइम लेंगे। तो ये नॉन रिप्रेजेंट हम लोग का जो रिप्रेजेंटेशन नहीं होता है उसके लिए ये। और दूसरी चीज है कि अगर दो कोर्ट में अगर स्टक हो रहे हैं, कोलाइड कर रहा है, तो अपना ब्रदर जो भी ग्रुप के मेंबर उसको प्रॉपर्ली असिस्ट कर
बुलाया है, एडी के रिप्रेजेंटेटिव को नहीं बुलाया, इसलिए बेटर एडी शुड कम।
इज कमिंग, आई एम नॉट रिप्रेजेंट, हमको अभी आए हैं
कोई बात, बिकॉज़ इस लेटर का हमको समझना है व्हाट इज द आइए स्टैंड
Lordship, one notice has been granted, and your lordship has
नहीं आप एंटिसिपेटरी बेल से शुरू करते हैं। व्हाट इज द केस अगेंस्ट यू?
Lordship, branch manager of Bank of Baroda has found some unusual transaction in certain bank accounts, and informed the cyber police, and this case was registered. Lordship, my involvement is only that for 15,000 rupees I have helped in opening bank accounts.
Different bank accounts?
No, Lordship, one bank account.
No.
Lordship, for Priyanshu and other 2-3.
Yes.
Lordship.
Not one.
Lordship.
Number of bank accounts in which huge money has been transacted.
Lordship. For 15,000 rupees, it is in FIR, Lordship, 15,000 rupees, but Lordship has rightly said that it is 50,000.
50,000, which is not 15,000.
Lordship, indirectly.
50,000. So you have taken 50,000 rupees to open bank account on the basis of forged documents. Forged documents, all these documents have been found to be forged during investigation. Those certificates of industry department, etc., was never issued, and those units do not exist. Even your unit does not exist. Even your unit, Kaveri Enterprises, does not exist.
Lordship exist करता है।
नहीं करता ना, ऐसा ही आया है।
छोटा सा फ्लावर मिल है, वही
नहीं आया है, नहीं है। It does not exist. It has come during investigation. It does not exist.
उसका सा आया है डायरी में फ्लावर मिल उसका चलता है।
कौन सा डायरी पढ़ने में लगता है आपको? दूसरा डायरी पढ़। कावेरी एंटरप्राइजेस नाम का किसी व्यवसायिक संस्थान नहीं है। It does not exist. You have helped these people to open numerous bank account based on forged documents. कोई antecedent है?
No. There are 11.
Yes, state. इनका बैंक अकाउंट का कुछ भी सीजन नहीं।
इनके बैंक अकाउंट में ट्रांसफर है लॉर्डशिप, इनके लड़के के नाम प्रियांशु।
लड़का नहीं है इनका, ये बार-बार यही बोलते हैं।
एक मिनट, जो एफआईआर को देखा जाए ऑनवर्ड हम पढ़ के दिखला देते हैं।
प्रियांशु is not his son.
प्रियांशु के फादर का नाम है मनीष सिंह और मेरे फादर का नाम है बलवंत सिंह।
आप मनीष सिंह का बहस कर रहे हैं ना? मनीष सिंह का ही बहस कर रहे हैं ना?
तो मनीष सिंह है ना?
जी लो, मनीष सिंह।
यस। प्रियांशु के फादर का नाम है मनीष सिंह।
जी लो।
ठीक है। और आप मनीष सिंह। प्रियांशु आपका बेटा है कि नहीं?
मेरे फादर का नाम है बलवंत।
आपके फादर का नाम आपका, यानी कि प्रियांशु के दादा का नाम हुआ बलवंत।
नहीं।
ठीक है।
ऐसा नहीं।
यस।
Lordship, from FIR. एरेडेला खाता के शाखा के खाताधारक प्रियांशु कुमार सिंह पिता मनीष कुमार सिंह के संबंध में पूछताछ करने पर बैंक ऑफ बड़ौदा के शाखा
आप मनीष कुमार सिंह है ना?
मनीष सिंह it has come in the last para, second last line of page number 70. प्रियांशु कुमार पिता मनीष कुमार सिंह से पूछताछ करने पर बताया गया कि अमन सिंह एवं अमन जायसवाल के निर्देश पर इन्होंने अपने फर्जी खाता खुलवाया था, जिसे मनीष कुमार सिंह पिता बलवंत सिंह 150 चमेली टावर जगीवनगर धनबाद में 15,000 रुपए की एवज में
All these bank accounts are forged. There is no such code existing.
अनएक्सपेक्टेड ट्रांजैक्शन भी पाया गया।
नहीं, उन बैंक अकाउंट्स में पाया गया ना। Just let me know one.
फॉल्स डॉक्यूमेंट्स से
There is an allegation that on the basis of forged documents, he helped them in
बिजनेस
opening the account.
अकाउंट इज बिजनेस अकाउंट।
Business.
Yes, and that business is not exist anymore.
Yes.
That is come in the investigation, and that in that business account there is several UPI transaction that is not explained by the.
कोई बोल देगा कि इन्होंने फोल्ड अकाउंट बनाया काफी।
नहीं, ये आया है आपके केस डायरी में है।
इनके बैंक अकाउंट से कोई ट्रांजैक्शन नहीं है। इनका तो बैंक अकाउंट भी आप सीज
नहीं है लोग।
नहीं। इनका बैंक अकाउंट नहीं।
इनके लड़के के नाम से है। नहीं तो
इन्होंने भी तो अपने नाम से बैंक अकाउंट कावेरी एंटरप्राइजेस खोला है।
इन्होंने भी
उनका बैंक अकाउंट, which is also you say is a forged bank account. It is not there. Mere allegation that he helped in opening forged bank account is not sufficient. कोई money transaction, कोई money claim नहीं है। And his bank account has not been seized.
देखिए लॉ के 1245 इस कांड के प्राथमिक अभियुक्त प्रियांशु द्वारा समर्पित म्युनिसिपल ट्रेडर्स लाइसेंस इतना सेकेंड अमन कुमार से समर्पित म्युनिसिपल ट्रेडर्स है, नैतिक कुमार से समर्पित म्युनिसिपल ट्रेडर्स संख्या इतना
डाउट कि जिनका इन्होंने बैंक अकाउंट खुलवाया जो एलिगेशन दे वर ऑल फॉल्स, लेकिन इन्होंने खुलवाया ऐसा इसका क्या एविडेंस? एंड इनका जो अकाउंट था यू हैव नॉट सीज्ड। कावेरी एंटरप्राइजेस का अकाउंट हैज नॉट बीन सीज्ड।
एक बार आप फिर से देख लेते हैं।
तब तक हम ऑर्डर नहीं और the learning council secreting on the office. The learning council for the petition says that the petitioner has been made accused in this case only on the ground.
तो प्रियांशु और मनीष का कन्फेशन है।
Only on the allegation that the petitioner has helped in opening fictitious bank account in the name of 3 persons, namely 3 persons, and in those accounts there were numerous transactions. The 3 persons were Priyanshu Kumar Singh, Aman Kumar Singh, and Naitik Kumar. The learning council summons that one bank account was also standing in the name of the petitioner, namely Kaveri Enterprises, and it is alleged that on the spot no such business enterprise existed. However, he says that there is neither any planting nor any money has been found in the bank account recorded in the name of
He has also submitted that there is no money claim found to connect the petitioner with the initiatives. The learned counsel for the state has opposed the plea for bail and has submitted that the petitioner was instrumental in fulfilling the fictitious bank accounts. But at the same time, he could not indicate any money claim connecting the petitioner with the alleged offence. Even during investigation, the bank account standing in the name of the petitioner in the name and style of Kaveri Enterprises has not been, the bank details of Kaveri Enterprises has not been. Previous the counsel for the petition says that charge sheet has been submitted. The petitioner has no criminal antecedent and is in custody since 8 June 2026. After hearing the learned counsel for the parties and considering the nature of allegation against the petitioner, but no material could be pointed out to link the petitioner with the opening of the fictitious bank account in the name of 3 persons. And even the bank account standing in the name of the even the details of the bank account standing in the name of the petitioner has not been collected during investigation. The petitioner had no criminal antecedent. So, Police in the United Kumar has been granted the privilege of anticipated bail by the order bench. This one, petitioner is identified.
इसमें दोनों के प्रियांशु के कन्फेशन में आया कि ये मनीष कुमार सिंह हमारे अकाउंट खोले और मनीष कुमार
सारा कन्फेशन में कोई मनी लिंक नहीं है और इनका ही बैंक अकाउंट ऑफ सीसी हो सकता है उसमें कुछ मिल जाता है। और एक चीज आपको प्लीज ये बैंक में एक यूजर होता है
उसका भी नाम नहीं है
वो नहीं नो लिंक Mr. Eti, I want to know what is the input of this letter. This letter that you have circulated with respect to the number of.
It has been prepared by the learned PP for convenience. So what happens is, in case of absence of any one of the APPs, the other one can one of the members of the group can attend that. So in the
mere attendance may not be sufficient.
Yes.
Because we need sufficient
assistance. Yes.
And merely because of case is being passed on to a near friend, they will not be able to assist. Of course, if they ask for a passover, I will certainly.
Yes, that is what we are discussing.
That we
Ornamental presence will not suffice. In the event one of the APPs on leave. So what happens normally, they inform, these are the list of my cases. Kindly
If the other APP is able to conduct, there is no problem. But most of the time I find that they are not ready because they are otherwise also busy with their own cases.
Yes.
So it is always, you can always pray for a passover, not today. There is no problem about it. But it appeared to us that specific APPs have been assigned particular quotas.
kindly see last below.
That
The
is what
priority is to be
convenience.
given by the concerned council. Priority is to be given by the concerned council. Not that it is not that in all cases
At
we not
least,
be.
so far as this case is concerned, I need lot of assistance from APP. Kindly instruct them to take passover. That is the proxy will not really
Yes,
serve the
I'll
purpose.
passover.
Because at times I also write in my order that APP has not been able to hunt down certain materials. So we go against the APP.
Yes. No, I will pass on.
That's all.
Sorry, my presence is also required in DB3. So
No, no problem. You see, there is no need, but this communication is important.
Item 6, BA 5159 of 2026.
But in this case, in this case, I am very sorry, ma'am, for not filing of the counter. Although I have received the diary also.
Counter activity is ready.
Not ready, I have received the case diary. But I pray one 10 minutes, and in the meantime, I right counter.
PA number 515 of 9/2026. The loan transfer for the state pays for and is granted time till this Thursday by way of last invoice to file the contract. This is on next. Payments.
Item 7, BA 5223 of 2026.
So the case was registered under section 376 It relates to a consensual relationship between two bidders lawsuit which continued for 4 years from 2019 to 2023 on the pretext of money.
What's the allegation?
The-
What is the allegation?
Yes.
Please verify.
Yes. It arises out of a complaint lawsuit.
Informant is appearing.
Lawsuit.
Informant is appearing in this case.
The lawsuit have been assigned file just day before yesterday
By whom?
by High Court Legal Services Committee. Your lordship, copy of bail petition has not been served. So if it may come tomorrow, I'll just go through the copy of the bail petition.
At the request of the learned counsel to be on behalf of the informant.
Yes.
The matter is directed to be posted as Wednesday evening. Yes.
Item 8, BA 5242 of 2026.
FIR was registered under information technology. But only on the basis of suspicion that the suspected phone number belongs to me, I have been made a accused of this case.
The phone number, the phone has been seized from you.
Yes.
So it is not a matter of suspicion, it has been seized from you. And there are numerous criminal cases of similar nature.
No, Your Lordship, not of similar nature. It's a
Several other criminal cases of similar nature. Patna Airport PS case number 73 of 25. Devar Cyber PS case number 169 of 2025. They are not of similar nature.
Your Lordship, in the counter affidavit, they have stated only about the Patna Hawai Adda, and which is of kidnapping, not of idea.
And what about this Devar PS case number 169 of 2025?
Your Lordship, in the counter affidavit, they
There
are not
there are
stated
two
it was in the
victims
info
also
order.
who have been cheated money. Against whom complaint was lodged.
You have not mentioned about in the antecedent report, you have not mentioned about that Devar PS case number.
Only about the Patna then.
Patna
And this
two acknowledgements.
Two acknowledgement regarding which
What about
victims.
this Dhanbad PS case number? Which is mentioned in the interview order itself. Devgar PS case number. Devgar Cyber PS case number 169 of 25.
I will verify.
You see, it is not registered against you.
Lordship, in the counter, they are not.
You forget about the counter.
We have
You
mentioned.
must be knowing whether the case has been registered against you
We
or
have
not.
mentioned two antecedents.
They have,
Two antecedents you have
they
mentioned.
have mentioned at
So we acknowledge that
paragraph
these two antecedents are there.
But in the counter, at last date, it was
How
asked
many
for
victims have been identified?
two victims.
Two victims. Amount
Amount from one 30,416 and other have not disclosed.
only one has been received.
since when are you in custody?
7126. And charge sheet has also been submitted. At the stage of charge sheet.
How many mobile and SIM has been recovered?
6 mobile and 6 SIMs.
6 mobile and 6 SIMs. All standing in your name?
No, Your Lordship, kindly have a look at paragraph 8 of the counter affidavit. There they
Why you are arguing from counter? I want to know these mobiles and
No,
SIMs are they standing in your name?
In others.
that is only there in paragraph 8.
Or the legal counsel appearing on behalf of the court. the counsel for the petition summons that the petition is not introduced in 17/2026. 6 mobile and 6 SIMs are alleged to have been recovered from the possession of the petitioner, standing in the name of the person. The summons that the petitioner has 2 human participants. However, one of them is not of civilian nature. The Learned Council for the state has opposed a play for women and has submitted that 3 victims have been identified. And as per the interim order itself, there is one criminal case of civilian nature registered against the petitioner at Baker, side of police case number 169 of 2025. And so far as Patna, Hawaii case number 73 of 25 is concerned, the same has been registered under section 147, 143, and 61. After hearing the Learned Council for the parties and considering the allegation that the mobile and the same seized from the possession of the petitioner, to which the petitioner had no explanation. And the charge sheet has been submitted under organized crime, and the petitioner has also one criminal antecedent. Victim has also been identified. This work is not inclined to remove the petitioner. However, the petitioner will his breath away after 6 months.
Item 9, PA 5310 of 1026.
This petition.
So last of all, very much finished the plot for this guy and anticipate the person who has come.
20 cases.
No case against me. In file 9 and file 12, in the counter affidavit, in file 9, the concluding 9, there are several criminal incidents found against the person Samanajama in Manapati PS and Validity PS case number in the file. But no criminal incident found against petition. Yes, file 9. Register your local police station and CCTNS and ICJS portal, all 59, 50 and 50. And again it is repeated in part 12 also at this 5. In the same
The wife of this Nawaz Ahmed has lodged the FIR, alleging that basically allegation against Nawaz, alleging that this petitioner had also found wrong. But
the petitioner along with Shahnawaz went into the house and broken several articles.
basically on the same day.
CCTV has been collected because she says that घर में लगे CCTV कैमरे से इनके कृत्य का आभास लगाया जा सकता है. CCTV फुटेज आ रही है.
इनका कहना है लेकिन ये साथ में करेंगे सीसीटीवी कैमरा तोड़ दिया. पहले आगे सीसीटीवी कैमरा ही तोड़ा. हस्बैंड को पता था कहाँ सीसीटीवी कैमरा है तो तोड़ दिया. तोड़ने के बाद घर तोड़ किया. इनके ऊपर तो सीरियस एलिगेशन है. पहले भी हस्बैंड के ऊपर पहले भी एक केस किया.
हस्बैंड के ऊपर तो बहुत एलिगेशन है लेकिन
इनके
ऊपर एलिगेशन है कि ये उसके साथ में घर में
साथ
घुसे
में आए।
हाँ, साथ में।
और कोई रिश्ता भी है आपका victim से?
नहीं, ये तो रिलेटिव तो होगी मुझे, ये तो आया नहीं है। And on the same day, what is exactly on the same day, 30 March 2026, and at the same time, 10:30 बजे रात में और 11 बजे रात में 2 FIR होता है। और तीसरा FIR की इन्फॉर्मेंट करती है, let's see also the wife of the Shahnawaz Jawad. Also, that case was registered under POCSO Act. And recently, at 8th of July, what's the date he has been able from the charges of
Not
POCSO?
the Council of Claiming of the Council for the Constitutional Science Act. As per the FIR, the main allegation is against the husband of the informant of the case. And it is alleged that the petitioner had also come to the place of occurrence along with the husband of the informant and we take ruckus in the place of occurrence. The learned counsel submits that the petitioner is in custody since
1/4/2026.
1/4/2026. Charge sheet has been submitted.
Yes, sir.
And the petitioner has no criminal antecedents. He submits that there are 20 criminal antecedents against the husband of the informant. But so far as the petitioner is concerned, he has no criminal antecedents. The learned counsel for the state has opposed the plea and has submitted that the petitioner was also involved in the commission of the offense as his appointment. As inasmuch as he has accompanied the husband of the informant and came to her house. After hearing the learned counsel for the parties and considering the fact that the main accused is the husband of the informant and no specific overt act is alleged against the petitioner. And charge sheet has already been submitted. The petition has been criminalized. The petition is to be charged.
Item 10, BA 5495 of 2026.
Under section 87 and 89 of business code, section 4 and 6 of this code. After 7 months date of occurrence, this case has been instituted by informant, the mother of victim. The case is that when she went to attend the call of nature, then this
She has fully supported the allegation in her statement recorded in section 183. And she has also been examined before, and again she is supporting the allegation.
but they are for 7 months matters after that. There is no matters.
20/8/2025, right?
20/8/2025 for date of occurrence, and FIR has been instituted on 24/8/2025.
24/8.
And between
साथ में SC ST भी लगता है। कौन है इसमें informant?
Minor lady for 15 years.
Minor age 15 years.
15 years. And she supported the case of the prosecution.
There's a delay of how many days?
due to matters 7 months, 7 months, 3 days, 4 days.
24/5/25 the case was instituted.
24/8.
24/5/25. 24/5.
FIR 24/8/2025 first page of annexure 1 first page.
is a delay of 8 months, around 8 months, right?
When he left her at Mirar Gadwa station, railway station, then this case has been instituted. When the difference has arose between the parties members, then
2 महीना रखा छोटे लाल 2 महीना
2 महीने
वहां से छोटे लाल मुझे हिमाचल ले
हाँ हिमाचल
वहां से 4 महीने मुझे रखा
हाँ।
छोटे लाल मेरे साथ जबरदस्ती सामान बनाया ये मुझे बंद कमरे में रखते थे इसलिए मैं भाग नहीं पाई उसी दौरान गड़बड़ी हो गई फिर दिल्ली गए और फिर घर वाले दिल्ली आए और हम लोगों को बुलाया और बच्चा गिराने के लिए कहा उसके बाद वहां से और the living constitution of the law the living constitution of the petitioner submits that the petitioner has been falsely indicated in this case and there is a delay of 8 months in government. The living constitution of the state and the reformed is aware of me and have submitted that there is direct and specific allegation against the petitioner, the victim belonging to the SC/ST community is aged 15 years and she has reported the entire incident in a statement recorded on section 183 BNSS, wherein she has stated as to how she was taken away to Himachal and then the petitioner has forcibly established physical relationship with her by keeping her long in the room and ultimately the family members of the petitioner came to them and called him and ultimately they came to in view of the statement of the victim recorded under section 183 BNSS. And admittedly the victim was minus on the list.
Item 11 BA 5554 of 2026.
Council for the petition service for Jharkhand Council, Mr. Jharkhand is contributing on account of personal reasons. Please set the microphone.
Item 12
submission. Neither the petitioner has provided me the copy of petition, nor the state has provided me the copy of counter.
Which case?
Serial number
12. It's follow me.
Item 12 BA 5572 of 2026.
Council for the informant is present. The council for the petitioner, I can request the council for the petitioner as well as the state are directed to serve their respective affidavits.
Learned counsel appeared at last date of hearing, but he did not say anything.
Even the notices were not issued.
During the course of the day, post this case control, as they did it. Dated रसीद बना के रसीद फाइल कर दीजिए, ठीक है? आप ही दीजिए भाई कॉपी में कौन दे? You have entered appearance by filing a file number.
Item 30 BA 5578 of 2026.
Yes, petition.
In this case, Dr. Bandra Singh, but she is suffering from viral fever.
The learned counsel for the petition seeks determined by submitting that the arguing counsel is unwilling. Act is request, close this case. When?
Next week.
Next week.
Next week.
Next week.
Item 14, BA 5612 of 2026.
Lost for the office center section 316 319 318 336 342 61 35 of the ALS 66 BC of 84 C of the IPA. As per the allegation, some informant received a secret information that some persons were
What has been recovered from you?
3 mobile phones and 1 ATM card.
What ATM?
1 ATM.
Standing in whose name?
Yes, on the petitioner, on the name of the petitioner.
All them on mobile and ATM.
Three phones which belongs to this petitioner and 2 SIM cards which has been seized is on the name of this petitioner, that is 7970
What
388.
about ATM?
ATM is also in the name of this petitioner.
So all of these things are
The belonging of this petitioner.
now these have been used for
No.
the commission of offence.
No, one mobile number was used in the commission of the offence, that is 72092 437.
It was not seized from you.
From one vehicle Anil Pandit. Yes. And from that phone mobile number, 96,500 was cheated by one Akshay Kothari. And the charge sheet has been submitted, though the Akshay Kothari has not been made charge sheet.
Fake call girl spot service.
Yes.
यही आगे का ही था कोई लोग फोन करके बोलते थे लड़की प्रोवाइड कर
तो
दो
आपके फोन से कोई लिंक नहीं
नहीं
सीजर लिस्ट
सीजर लिस्ट है is 16 is 16 ऊपर में है पहला नंबर अनिल पंडित का एंड नीचे में है 1 2 3 4 5 6 7 8 9 हेलो बंटू कुमार पेज 16
में
ऊपर
ये है
अनिल पंडित का शुरू में
अनिल पंडित
यस उसके बाद 8 लाइन तो बंटू कुमार 2 नंबर दैट इज द पेटिशन एक
दो नंबर का
2 नंबर है उसमें
एक तो अनिल पंडित है सीरियल नंबर 3 में
वन पेज नंबर 16
हाँ
है ना
हाँ उसके बाद बंटू
जब्त किए गए स्थानों में
बंटू कुमार
यस बंटू कुमार एक उजला रंग का ओप्पो एस का मोबाइल है उसका ईएमआई नंबर लिखा हुआ है 2 सिम उसके बाद व्हाट्सएप नंबर उसमें जो है उसके बाद दूसरा नंबर में एक ब्लू रंग का सैमसंग गैलेक्सी A35 जिसका ईएमआई नंबर और सिम नंबर एक व्हाट्सएप नंबर है 2 व्हाट्सएप नंबर ये दोनों नंबर मेरा है एक काला रंग का रेडमी 8 मोबाइल नंबर ईएमआई नंबर दिया हुआ है और व्हाट्सएप नंबर और एक एटीएम बस कोई एंटीसीडेंट नहीं है लॉर्डशिप ये क्वार्टर में भी आया है और हम भी
कोई
काउंटर
एंटीसीडेंट
पे एंटीसीडेंट है
कितना एंटीसीडेंट है
अनिल नहीं है
है
कहाँ
बंटू कुमार
मंटू कुमार
अच्छा आप बंटू कुमार
जी देखा कोई
मंटू का है
आप ही लिखिए आप ही का बोल
68 और 26 केस नंबर कौन सा है चल
यही है
68 और 26
यस
मंटू का है केस डायरी में से
ये तो
बताइए ना
पैरा 14 में आप लिखे आप ठीक है
या आप लिखे होंगे तो गलती लिखा होगा
हाँ, बताइए।
उसको से
ठीक है
कहाँ है
ये
यहाँ पे जो लेक्चर लगा हुआ है उसमें
एक चार्ट बना हुआ है पेज 39
हाँ
नहीं है इसी केस का इसी केस का नंबर डालो
नहीं है और ये बोल रहे हैं इनके किसी मोबाइल से कोई लिंक नहीं है
एक लिंक है लॉर्डशिप जो एफआईआर में ही है लॉर्डशिप एफआईआर को ही पढ़ा जाए जहाँ इनके बारे में लिखा गया है जो इनका एफआईआर का सेकंड पेज हम केस डायरी से पढ़ रहे हैं। ये बीच से है मंटू कुमार पंडित के पास से तलाशी लिया, उसके पास से एक गुजरान का इतना 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 सर्विस व्हाट्सएप पाया गया, व्हाट्सएप नंबर इतना एक पाया, मोबाइल नंबर इतना, सिम नंबर इतना इतना, तो 2 सिम नंबर दिया गया, इसमें प्रतिबिंब पोर्टल एक्नॉलेजमेंट नंबर इतना। Acknowledgement number to the प्रतिबिंब portal acknowledgement number, meaning that there are one crime link in the प्रतिबिंब.
For the learning council's approval, we have the learning council the petitioner is in custody since
Custody since 14/4/2026.
14/4/2026.
I have mentioned in para 11.
And traffic has already been submitted. He has no female antecedent. The learning council says that as per the allegation, the petitioner and others used to run a service app, namely paid service app.
Girls Squad Service.
Namely girls escort service, and were involved in defrauding the various persons. The learning council submits that so far as the recovery of mobile and SIM from the petitioner is concerned, none of them is alleged to have been linked with any of the persons who have been defrauded. The learning council for the state as a force of prayer for bail and has submitted that one family has been found in the court. But the other submissions made by the council for the petitioner is not in the state. After hearing the learning council for the party and considering the fact that the petitioner has no female antecedent and traffic has already been submitted, the petitioner is free to pay.
All right.
Item 15, PA 5648 of 2026.
This section non-billable offence is 109 and 74. That is corresponding section is 307 and 354. Yes, 17 is the FIR.
Ganpat Rai.
Ganpat.
You are the assailant.
No, Lordship. The person whom I assault him, the injury found is simple injury. Only Rasmi Devi, he has found grievous in hand, Lordship.
Yes.
And I have a statement. I have Lordship.
No, just a moment. Did you meet Rashmi Devi?
No, Lordship. I have a statement. Para 6.
Who has been Rashmi Devi?
Yes, Lordship. Para 6, Rasmi Devi, the witnesses, they have deposed, Lordship.
They stated what?
May I read, Lordship, the relevant portion, Lordship?
ये क्या evidence पढ़ा है?
नहीं, sorry. Statement in under section. जो इंजर्ड है, आगे बताएं कि वादी दुलार चंद मेरे पति हैं। आगे बताएं कि घर के बगल में 5 डिसमिल पे जमीन दे दीजिए, केस एंड काउंटर के सजमिटी लैंड डिस्प्यूट पर दुलार चंद पंडित मियाँ 21 में खरीदे थे, जिसके घटना के दिन इतना के समय 8 बजे मेरे पति और मेरा बेटा घर बनवाने के लिए अपने जमीन में मापी करवा रहे थे। उसी समय अचानक गणपत राय, पिंटू राय अचानक मेरे जमीन पे आए और मेरा बेटा रोशन कुमार पिंटू एंड मेरे पति दुलार चंद पंडित को माथा पे हथियार से मारा। सिंपल इन नेचर, जिससे मेरा पति और मेरे बेटा पे बहुत खून निकलने लगा। उसके बाद मेरे साथ गणपत राय एवं पिंटू राय के साथ आए, इसके बाद रिलेवेंट ज्योति कुमारी, उर्मिला देवी, हेमा देवी मिलकर हमारे साथ मार किया और मेरे शरीर से साड़ी खींच लिया और सड़क पे पटक कर लोहे से रक्त मारा। दिस 3 पर्सन और लॉर्डशिप, इनका जो हाथ में इंजुरी है और जो इसको मारे हैं और साड़ी खींचने का एलिगेशन है। मेरा सिंपल इन नेचर है, हम जिसको मारे। केस एंड काउंटर केस, चार्जशीट में नो एंट्रीज।
Petitioner is in custody.
4/5/2026.
4/5/26 statute has already been submitted. And so far as the case is concerned, there is an allegation. so far against the petitioner that he had assaulted
Rod and
informant and his daughter.
Assaulted the informant and his daughter, but they have suffered simple injuries. So far as grievous injury is concerned, one of the victims has suffered grievous injury, but she was not assaulted by the petitioner, and she has suffered grievous injury in her hand and shoulder. He has also submitted that a number of courts have been extended the privilege of anticipated bail by Korean Court of Disco in the area of 506.
I file a counter.
क्या बोलना बोलिए?
और the grievous signature is had by here.
इनके ऊपर तो नहीं है ना?
इनके साथ गए थे.
इनके साथ.
इनके पास long.
The learning council for the state has also declared for bail and has submitted that the person who had given who has caused grievous injury were accompanying the petitioner. Although no overt act is against the petitioner with respect to the victim who suffered grievous. The other submissions made by the counsel for the petitioner is not participated. Contract between 5 million proceedings is taken up. After hearing the learning counsel for the parties and considering the fact that has found that there is an dispute between the parties, and so far as the petitioner is concerned, there is no overt act against the petitioner with respect to the person who suffered grievous injury. In such circumstances, the petitioner is directed to be involved.
Item 16, BA 5061 of 1026.
In this case, I pray for 2 weeks time to file counter affidavit. I have received the papers, but with the some.
The learning counsel for the state 2 weeks for even suppose.
Please
Granted time till next Wednesday to file counter affidavit. In this case, by way of last this.
थोड़ा और टाइम
जेल में ऐसा इसको जेल से निकाल देते हैं.
कुछ दिक्कत है इससे भी हमको.
जेल में है. आप केस डायरी आ गया, केस डायरी से बहस करिए काउंटर में.
ठीक, नेक्स्ट वही कर देंगे. नेक्स्ट वीक वही कर देंगे.
By way of last tax दे दिए हैं. केस डायरी से बहस.
Item 17, BA 5693 of 1026.
Case in cyber fraud, and this petitioner is in custody since 7/4/26. He is not named in the FIR. His name has come in the confessional statement of court views.
Just a moment.
And
7/4/26. You are not named.
I am not named. And my lord, the case of the prosecution, as per the FIR, that 2 persons were apprehended. They were selling diesel at a lower price, and they disclosed that one Kishore Mandal used to send them money through which they purchased the diesel from the HP petrol pump, and thereafter they used to sell them in the local market at lower price.
How is it possible?
This is what is there in the FIR.
You filed your counter.
Yes, I have already filed the counter affidavit.
Let us see the record.
This is the case of utilizing the money of the cyber proceeds law.
Yes, my lord.
And this person made the payment for the purchasing the diesel through his wallet lot and purchased the diesel and provided to others to sell out and obtain the cash from the selling the diesel. किसी के अकाउंट में साइबर क्राइम का रुपया गया, वो अपने बैलेट से रुपया पे डीजल खरीदे और डीजल को बेच के कैश कर.
My lord, there is no evidence that my account had received any money of cyber fraud. जो भी है, हमारा कभी किसी के साथ मेरा 2 एंटीसीडेंट है. I have got 2 antecedents of the similar nature, and this is the reason why my name has surfaced in this case. पूरा काउंटर में भी इनके पास कोई एविडेंस नहीं है, डायरी में एविडेंस नहीं है कि हम किसी के साथ साइबर फ्रॉड I have committed cyber fraud. और एक on one occasion I was there in the premises of the petrol pump. वहां पर हमने अपने HP पे वैलेट से I have made the payments. हम किसी को पैसा भेजे भी नहीं डीजल परचेस करने के लिए. And the किशोर मंडल, उसको डिस्ट्रिक्ट से ही पेन हो गया. Who used to send money to those 2 persons for purchasing diesel. Charge sheet is already submitted.
Which paragraph of the paper you have you
काउंटर के पैरा 18 में उन्होंने लिखा है his mobile was found active.
पारा 13 में है ये 2 criminal antecedent notes. Of the supplementary.
And what is there against him in this case?
पारा 32 में है नोट्स. 38 and 32 में है mobile phone number whereby the payment done at the petrol pump belongs to Sonu Kumar. This is
if mobile payment is done at the petrol pump, he becomes a criminal.
My lord, पैरा 32 हम
आपको मना किया ना बोलने.
नहीं, इसमें ये बोल रहे हैं कि वहां से पेमेंट हुआ.
आपको मना किया. जब आपकी बात आएगी तो आपको सुनना होगा. बिना सुनकर बोलिए.
ये 32 में है सीनियर अवलोकन क्या मोबाइल नंबर इतना के धारक मनोज कुमार महतो पिता नरेश कुमार नाम से निर्गत है जिसका टावर पत्रकामा क्षेत्र पाएगा. 2 मोबाइल नंबर के धारक परिणाम ये है इसमें साया गया है. धारक विपुल कुमार मंडल है, पारसपानी है, महागामा है. मोबाइल नंबर इतना के धारक सोनू कुमार मंडल पिता छेदी ये डिस्क्राइब किया हुआ है. जिला गोटा के नाम से निर्गत है जिसका टावर लोकेशन है कई समस्या है तथा इनका इस दौरान टावर लोकेशन ग्राम गड़ो बाजार आदि गोटा पाया गया है एवं मोबाइल नंबर धारक इतना ये जो डिफरेंट सिम पाया गया है तो 1 सिम जिससे पेमेंट किया गया है वो पाया गया इनके नाम से.
सिम जिससे पेमेंट किया गया है, पेमेंट करना कोई क्राइम नहीं. आप ये बताइए कि इनके पास जो पैसा था वो क्राइम
वो डिस्क्राइब नहीं है. वो डिस्क्राइब नहीं.
पैसा तो कहीं नहीं.
वो नहीं लिखा.
38
ये स्टार्ट किया नारायण मत उसके गांव जिन्होंने बताया कि हमारे गांव में किशोर नवाज जेल गया था. जेल से निकलने का गांव के कई लड़कों को मोबाइल से पैसा गलत तरीके से ठगने का दिखाई दिया जिससे गांव के कई लड़का साइबर माध्यम से दूसरे का रुपया ठगी करने लगा. किशोर बराबर से लोटिया करने लगा. विपुल कुमार मंडल, सोनू कुमार मंडल, विक्रम कुमार मंडल के साथ साइबर क्राइम के पैसा से पेट्रोल पंप से डीजल खरीद कर कम दाम में इधर उधर बेचता है. किशोर मंडल कई गाँव के लड़के को बाहर से सिंगला कर दिया तथा शिव नारायण महतो का बेटा रविंद्र महतो जो हाई स्कूल में पढ़ता है गाँव के गोपी चंद को दिया गया है. बेटा को बाला बुजुर्ग से लेके किया. नेक्स्ट उसी का पारा 39 में किशोर मंडल मोबाइल के माध्यम से सोनू को एवं पैसा भेजता है तथा उससे डीजल खरीदवा कर कम दाम में बेचवाता है. पैसा साला प्रभाकर मंडल के माध्यम से लेता है. तो किशोर मंडल ये इंडिपेंडेंट विटनेसेस विलेज के जो बोले कि किशोर मंडल साइबर क्रिमिनल है, तो साइबर क्राइम का रुपया सोनू के अकाउंट में भेजता है और सोनू से डीजल परचेज करके अपने से वापस।
ये जो 38, 39 बोले दोनों गांव के लोग हैं, तो साइबर का कहाँ से पैसा आया इसका कहीं कोई जिक्र नहीं, पूरे डायरी में कोई मेंशन
The petitioner has been falsely implicated in this case and he is in custody since September 26. He is not named in the FIR and charge sheet has already been sent. The counsel for the summons that the petitioner has no criminal antecedent of similarity and therefore the petitioner has been falsely implicated. The legal counsel for the state has opposed the court of him and asserted that the proceeds of cyber crime has been imputed through the petitioner and the phone has been purchased and sold at lower rate. So that the amount would be and so that lower rate. To some extent, the statement of the persons of the locality has come, which indicate that the petitioner, after being released from jail, has been training the other persons in the locality to commit cybercrime and has been utilizing and Kishore Mandal, who is a cybercrime criminal, used to send money to the petitioner and Kishore Mandal. And that money was utilized for the purposes of buying diesel and selling it at less rate, and then the money was used through for money. However, during the course of arguments, the legal counsel for the respondent has not been able to show any money trail in connection with the involvement of the petition. After meeting the legal counsel for the parties and considering the aforesaid facts and circumstances, and there appears to be an allegation that the petitioner has been involved in training the other persons to commit cybercrime and has been using the proceeds of cybercrime to his account, but no including connecting the money trail to be found in the precise connecting the petitioner with the evidence for only the petitioner is able to be
Item 18, BA 5696 of 2026.
section from also.
So and so means what? Read the FIR.
Under section. Also page number 11 of the.
What is the allegation in short to the status?
Allegation is that as per the statement of the victim, there is relation between the victim and the petitioner, and both are in relationship. After some time, the petitioner refused to marry the victim. Therefore, the present case has been filed against the petitioner. But the true fact is not stated in the FIR also. I have filed 2 supplementary affidavits bringing on record certain facts and records. Okay. Before filing of the FIR also, there is some transaction between the victim and her relatives with the petitioner.
Charge sheet has been submitted under which section? Charge sheet has been submitted under which section? Both were working in the hospital.
Both petitioner was working as a ward boy in the hospital, and the victim was working as a trainee, GNM trainee. Petitioner is victim is well within the knowledge of the medicine and is insufficient.
Under which section charge sheet has been submitted? Who is for the informant? You are for the informant?
Yes.
Yes. He says that there was love relationship between them.
No, Your Lordship, the case diary specifically.
His daddy आप FIR पढ़िए ना?
हाँ
His daddy तो बाद में.
हाँ वो ये लव किए कि शादी करेंगे
हाँ.
और उसके बाद ये शादी से इनकार कर गए.
प्रेम संबंध में बदल गया. They started having some relationship and ultimately he did not.
Ultimately he did not. But the aspirations.
भाषा देखकर कोई प्रेम संबंध बनाया उसके बाद.
Aspirations was of marriage.
No.
Yes,
ऐसा नहीं है.
Lordship sees paper.
Lordship sees second. Lordship sees second supplementary affidavit filed by the petitioner. The mother of the petitioner filed a case, complaint case against the victim and her relatives, stating there is certain facts. Since petitioner is in custody, therefore he is not able to depose his statement before the London Lordship.
Lordship, in this case,
वॉर्ड बॉय का काम करता था. हम दोनों की मुलाकात प्रेम संबंध में बदल गई. Right?
yes,
पहले प्रेम संबंध हुआ उसके बाद हुआ फिजिकल.
on the assurance that he will marry. On the assurance.
Parties, when the counsel for the petitioner has submitted that the petitioner as well as the victim were working in the hospital. The petitioner was a ward boy and the victim was undergoing something. GNM training. Both were major. It means that as per the FIR itself, both of them they developed love relationship, and it is alleged in the FIR that in the pretext of marriage, the petitioner established physical relationship with the victim and ultimately refused to marry. The learned counsel for the informant and the state have proposed a prayer for bail. This counsel for the petitioner says that no antecedent, the petitioner has been given antecedent and charged as offense after hearing the learned counsel for the parties and considering the fact that as per the FIR itself, some love relationship developed between the petitioner and the victim. Were there, were working / taking training in the hospital, and charge sheet has already been submitted. The petitioner has no criminal antecedent. The petitioner is
Item 19, PA 5723 of 2026.
The petitioner has been implicated in the case registered for the offence under section 1031, 1 and 3 of BNS. As per the FIR, which is in page number 70. The petitioner is not named in the FIR, but I may permit to read the FIR. Page 17 is the FIR. May I read? पेज नंबर 17 में विद्या कुमारी सचिव प्रधान अंकित कराते हुए कल दिनांक 25/1/26 को 5:30 बजे मेरी सास शांति देवी अपने दामाद सुरेश रतिया का बैल चलाकर घर वापस आई तो मेरे घर कर 300 मीटर की दूरी पर एक ही गांव में घर आने के बाद मैंने अपनी सास को खाना खाने के लिए कहा तो उन्हें खाना खाने से इनकार कर दिया और मैं बासी खाना नहीं खाऊंगा और यह कहकर मैं अपने दामाद के घर गर्म खाना खाने जा रही हूँ। करीब 7 बजे मेरे सास के घर से निकल अपनी बेटी बीना देवी के घर जा रही थी। जाने के रास्ते में ही एक गली है, उसमें 3 व्यक्ति बालेश्वर रौतिया, लालमोहन रौतिया, धर्मराज रौतिया, थाना जिला गुमला, इन लोगों ने मेरे सास को गाली गलौज करते यह कहना है कि औरत डायन है, इसी में गांव के कई लोग जान मिले मुझे खत्म कर देंगे। जब ये लोग मारपीट कर रहे तो मैं सुनी और अपने पति कमलेश रौतिया को बताई, लेकिन नशे की हालत में सोया हुआ था, जिस कारण वो उठा भी नहीं। जिसके बाद मैंने अपने ननद बीना देवी को फोन किया, फोन नहीं उठाया। इसी वर्ष एक बार लालमोहन के हाथ में तलवार लेकर घर आया था और बोला था कि तुम डायन हो, तुमको काट देंगे, ये लोग मुझे मार देंगे। लेकिन मैं डर से इन लोगों के पास मेरी सास को छुड़ाने नहीं गई। इसके बाद वे सभी मेरी सास को लेकर चले गए। 26/1/24 सुबह 6 बजे मेरी बड़ी सास से जानकारी दी कि तुम्हारी सास कुशल अम्बा के पास रोड के नीचे खून से लथपथ मरी पड़ी है। उसके बाद वहां जाकर देखा तो मेरे सास को बेरहमी से पत्थर से मारकर दिया गया। इसके बाद आसपास के लोग जमा हो गए, थाना को सूचना दिया। After registration of the FIR, police entered into an investigation of the in course of that all these 3 petitioners have been apprehended by the police. They confessed their guilt on the basis of which charge sheet was also submitted. But subsequently, after 15 days of the occurrence, one statement was recorded in paragraph number 59 of case diary. That is, when Kinua Retua has appeared before the police, and he has recorded his statement, stating therein that on the date of occurrence he has seen the present petitioner at the place of occurrence on the date of occurrence. Only thing was what he has seen, that this petitioner was seen nearby at the place of occurrence on the date of. On the basis of the petitioner apprehended by the police, and when his confession was recorded, he confessed his guilt. And it has also been stated that on his confession, some SS has been recovered. No incriminating article has been recovered from his confession. However, on some SS has been recovered, and on the basis of which petitioner has been remanded, on the basis of which the petitioner is in custody. There is a specific allegation against the accused persons, and they have submitted, and against them also charge sheet has been submitted. And thereafter 15 days, one witness who has not been examined, has not given any information at the time of registration of FIR. 15 days, one chance witness has come and has one. And
my lords, kindly see the order granting bail to the co-accused. Your ladyship has granted bail.
After hearing it, I will also take 2 minutes.
Ladyship, first, what the petitioner deposed that on his disclosure, the burnt clothes was found. Kindly appreciate my lords.
Wrong submission.
Para 63 of the case then.
नहीं बोलेगा।
तो ज़्यादा बोलना है उसके खिलाफ ही होता है।
ठीक नहीं बोलता।
Petitioner is my lord Bittu Rauti.
Yes, sir. On his confession statement, there was recovery.
Yes, my lords. One more thing which I would like to submit to your lordship. There was motive which is attributed to the present petitioner. It was stated that the co-accused person had instigated him, that as because your wife is not able to conceive for more than 5 years after your marriage, this lady is a dyer and she must be killed. And thereafter he has committed murder. And also in his confession statement, he has said that the lady, while having a scuffle, had abused him. And thereafter he, with a patthar, my lords, he on the head of the deceased attacked this present petitioner. He is the main.
हम तो कुछ बोलेंगे. Kindly the order last passed by lordship में kindly listen. There are four. My lord. नहीं हम अपने फेवर में नहीं हमारे अगेंस्ट में रिलाई कर रहे हो. There are 4 paragraphs that been referred. 59, 61, 81, 82 and 70. Kindly all these paragraphs में kindly listen. What is against? Kindly come to the case diary. मेरे अगेंस्ट में मेरा कन्फेशन है. मेरे अगेंस्ट में कन्फेशन है. रिकवरी जो कन्फेशन लीड टू रिकवरी जो बोल रहे हैं वो एसेस ऑफ द some SS has been recovered. It has been said it is the cloth SS of burn cloth. हम पढ़ दे रहे हैं paragraph number 64. मतलब 64. Yes, I am reading. राजेश अपने अपराधिक रोहतिया अपराध सॉरी अभियुक्त बीतू रोहतिया अपराध का बयान मेरे समझ हुआ. उसके बताने से पुलिस जंगल में बीतू जलाया गया कपड़ा का राख को जब्त किया गया. Some rock SS has been recovered. Whether it is of the clothes or not, it is not clear. But only there is some SS has been on the basis of the recovery of and some SS. Can a petitioner can it be relevant under section 26 of the Evidence Act? Cannot be because it is not a relevant article. Relevant article. And
and he has been falsely implicated in this case. The 11th Council summons that the petitioner is not named in the FIR, but his name has transpired in the confession statement, in his confession statement, and it is alleged that on the basis of his confession statement, the ashes of blood-stained clothes were seized. Clothes of the victim were seized.
no, cloth has not been removed.
Blood-stained ashes of his blood-stained clothes were seized. The 11th Council summons that the ashes by itself cannot link the petitioner to the instruments. The 11th Council for the petition has also submitted that after a few days, one eyewitness appeared, namely Kimbara Yokua, who in his statement said that during the night of the occurrence, he had seen the petitioner near the bushes where the dead body of the deceased was lying. The 11th Council for the Informant and the state have accused of their body. The Council for the Informant has submitted that the wife of the petitioner was not conceiving, and therefore it was alleged that the deceased was a dying, and ultimately she was killed by turning her as dying. She was killed by stone.
Yes, ma'am. This is eyewitness.
Yes.
Eyewitness. She has stated some another story.
The 11th Council has submitted that the name of the petitioner has not only transpired in the statement of Hinuma Rathia, who stated that the petitioner was seen near the bushes where the dead body of Shanti Devi was lying. But he had also confessed that after committing murder, he burned the blood-stained clothes and showed the same, and the ashes were recovered.
Kinma has not stated that it was burnt. It was blood stained out. Wearing apparel were in blood stained. It was not stated.
The petitioner in his confession.
Hi.
This is what I.
Yeah.
After holding the 11th Council for the parties and considering the fact that the case is of the mother of a lady who died
Others have been granted bail.
By turning her as dying, and materials have been collected against the petitioner during investigation. This court is not inclined to
And what order of bail co-accused has been granted, that has also been indicated.
The co-accused has been granted bail in real numbers 5/28 of 2026 in Rameshwar Rajya and Bangalore.
The main issues are named have been granted.
The order of the bail order means that this court has taken into consideration that on the basis of the condition statement of the accused, the recovery was made. Namely, the case stands, or the petition stands on the as that of the accused.
Item 20, BA 5724 of 2026.
Order passed by your lordship, I have already complied. Order passed by your lordship, I have already complied.
The last occasion, state was directed to file the counter
Is diary
to serve the notice of appointment that has been validly served. Counter has been filed on very
डायरी के लिए बोला है कि कोर्ट में डायरी देनी पड़ती है इसको तो लास्ट
Statement of BNS.
है
इसके लगाए
डायरी में दिया पड़ेगा पेज 29 मैम
Page 29 का 183 का statement होगी ना
है मेरे पास
Page 29
हाँ पेज अब तक केस डायरी
Page 16 is
योर्स
petitioner का नाम है
इसका नाम है
रोशन
रोशन कुमार दास
supplementary affidavit, उसमें deposition लगा है victim का emotion, in which she has clearly stated that. मैं read your motion.
बताइए ना क्या बोल रही है
उसमें लिखा है कि हम शादी से खुश नहीं थे, मैं बालिग हूँ इसलिए मैं घर वाले शादी करवा दिए थे.
क्या बोला
was at the time of progress my lord she was minor my
लेकिन घर वाले जबरदस्ती शादी करा दी
वो तो उसका
तो भाग गई और भाग के दिल्ली गई और दिल्ली में जाके लड़का बना ये तो है और दलाली पास में गया दलाली ट्रांसफर of the petition summons for the petitioner has been falsely implicated in this case. She submits that though the victim was minor at the relevant point of time, but she has stated in a deposition before the court that her family members got her forcibly married to another person, and then she was not happy with the marriage and left with her friend where she called and she was having love affair with the teacher and they stayed together in Delhi. As husband and wife. The victim has been declared hostile. The statement of the victim record from section 183 has also been placed on record, which is on similar lines. The transfer of the state has opposed the prayer for appeal. Neither the refuted submissions made to the council for the petitioner is not accepted. In view of the refuted facts and circumstances and the statement of the victim of the body and seeking down to the cases, and also the fact that the victim has turned hostile in favor of the petition is that to be
Item 21, BA 5728 of 2026.
Now I have to that I have to
the legal counsel for the raised that the matter be posted to so contract will try to the proceeding system.
His favorable. It's the victim. Counsel to the victim.
Counsel for the victim is also present. He is taken in the body to treat the yes was also present. Next.
Item 22, BA 5745 of 2026. Along with item 23.
There is a recovery of 1 mobile and 1 SIM. Petitioner has not moving and recent. There is no crime link, no victim.
So counter का डायरेक्शन सब तीनों benches.
पहले ये वाला लिखते हैं BA 5743 और हेडिंग क्या रिकवरी
1 mobile and 1 SIM.
1 mobile 1 SIM.
There is no crime link and no victim has been found. Petition.
No crime link.
No crime link, no victim.
No victim.
No.
Any antecedent.
There was one antecedent of 2019, but he has been acquitted from the same. As mentally impaired person. Apart from the same, he has got no criminal.
बताइए क्या बोल रहे हैं?
The victim has seen in the name of other cell of document.
Victim नहीं है कोई crime नहीं हुई. No antecedent.
एक
अब तो वो equal हो गया ना उसमें. He has been acquitted in that case.
नहीं victim नहीं है.
Custody कब से?
Custody 30/4/2026.
Please charge.
Yes.
Charge to
Yes.
or the legal counsel से pay. On behalf of the legal counsel for the petition submits that the petition is in custody since October 2026 and charge sheet has been submitted. One mobile and 1 SIM is alleged to have been recovered from the possession of the petition. No family has been found during the investigation and no victim has been identified. Non-capital filed the report to students is taken on. The service as a petitioner had one criminal antecedent of 2019 in which he has been acquitted. He refers to para number 14 of the Bail Act. The learned counsel for the state has opposed the prayer for bail. However, the posted submissions made by the counsel for the petitioner is not accepted. After hearing the counsel for the parties and considering the fact that charges has been submitted, but no crime has been found, nor any victim has been identified. The petitioner is to be acquitted. Crime का victim दोनों नहीं है ना, ये बात सच है कि नहीं?
चेक कर पाते हैं.
आपके काउंटर में होगा ना?
लिख दिया है.
Crime link का वो नहीं आया है.
Last page में
This was 23. One update. Number 569/26. Counsel for the petition submits that party counsel is not available on account of personal reasons that is due to expose this case only. Contract with primary court proceedings is taken. ये कौन सा वाला केस था? नंबर
5695. 5695.
5695 ये उसका नाम है. और next
Item 24.
In this case also no crime names, no victim, no antecedent. One mobile. Custody same lordship 34 2026. Charge sheet submitted.
no crime name,
No crime name,
no
no
victim,
victim,
no antecedent.
no antecedent.
सिर्फ मोबाइल रिकवरी पे आपको क्या शिफ्ट कर दें?
एक साथ पकड़े गए हैं और सिर्फ दूसरे जो दो कुछ कैरेक्टर जो एड ऑन हुआ, एक और जो उनका बेल पिटीशन नहीं, उनका विक्टिम पाया गया, एक साथ साथ पाया गया.
और the learning council से भी आप council for the petition however no primary no victim has been identified with respect to the recovered mobile/SIM phones in possession of the petitioner has been identified. The learning council of the state has approved the recovery and was however, the reported submissions made by the council for the petition is not in dispute. The contract will be filed within court proceedings is taken. In view of the reported facts and circumstances, the petitioner by both moving to the the petitioner is directed to be
Item 25. BA 5752 of 2026 along with item 26 and 27.
same day. All the cases, Mr. Rahul Vindhya is there.
No, only 26, 27 and 20, 26, 27.
25.
Number 26. Serial number 26, 27 will be the council for the petition submits that. The Jharkhand council, Mr. Rahul Vindhya is not available for his personal reasons at his request goes this case to 10th of August. Nobody appears on behalf of the petitioner in the third case. Post these cases on 10th of August. 25 में nobody appears.
26, 27.
26 weeks.
25.
25 में nobody. उन्हीं का नाम लेकिन appear.
25. BA 5752.
G 25, 26, 27.
तीनों केस का वही लिखते हैं.
Item 28. BA 5778 of 2026.
Wait, please. Earlier, the state was directed to file counter. Now, the FIR allegation that since May 2025, the petitioner has taken the prosecutrix to several places on the pretext of giving a big mobile, which was given to them. When the family members, the parents came to know about that mobile, they have approached the family of this petitioner for marriage. That has come in the case diary. The statement of parents of the prosecutrix is there, wherein they have stated that after coming to know about the incidents, they have went to the house of the petitioner and thereafter he refused to marry.
Subsequently, this petitioner has came to the house of the prosecutrix and snatched the mobile phone which he has given to her and has broken. Thereafter, the case has been lodged in 2026, that is on 13/4/2026. Now, the entire occurrence, as per the FIR, that has taken place way back in 2025. The statement of the victim is also there in the case diary, wherein she has stated that she does not know where she has gone. She has not given the description of
She has given a statement under section 183.
183.
Where she has fully directed everything. Who is the informant of the case?
Informant is the prosecutrix also. Now, the medical report, it suggests that the victim is aged about 17 to 18 years. That is there in the case diary of the medical report. And no evidence of any sexual activity was found as per the medical report.
As per the school certificate, the date of birth is
1/1/2011. This is my the time of offense.
What the movie comes at supporting the law. When you are constituted, the petition says that the petitioner is 26 years, is in custody, and charge sheet has already been cited for against the petition. He says that the petitioner has been falsely indicated in this case that is anonymous delay in logging of the file. The Memory Council has also submitted that the victim herself is the informant of the case, and she has stated that the petitioner had taken her to a lodge in Jharkhand by stating that he would buy a mobile phone to her, and then he was kept in a lodge, and then the petitioner established physical relationship with her. The Memory Council says that as per the FIR, the victim moved with the petitioner from place to place, and ultimately when she was brought, she filed the Memory Council stated the date of birth of the victim as per the record says 1 as per school record was 1/1/2011, and victim was aged around 15 years on the date of the file. The statement of the victim recorded under section 182(b)(6), which has been called for as the case number. The statement of the victim means that she has fully supported the prosecution case. After hearing the Memory Council for the parties and considering the current condition with respect to the victim who was 15 years of age on the initial date of occurrence in the month of May 2025, this court is not inclined to impose a petition number.
Item 29, BA 5901 of 2026 along with item 30 and 31.
If that is required, the petitioner said to be the owner of the hotel, the offense under section 290 and under IPNSS and Immoral Traffic Act. But incidentally, what happened? I am the father, and my son was running the hotel. This has also come in the case diary.
Son was running the hotel.
Yes,
Hotel was in whose name?
The hotel was named the son. He was running the hotel, and I was running the Gosala. I gone there to what the police reached. I gone there and I was implicated. It is affirmed by the case diary. Paragraph 56 may be seen. First blood, I am relying on the blood directed 2 page 23. The hotel's document that is in favor of my son. Annexure 2, page 20. He is the main accused, and his other friend is the main accused. And because I have gone to visit the hotel, I was arrested. But kindly see, Sudhir Kumar, my son.
What is the date of birth?
Date of FIR 19/5/2026. This has been issued on 29/9/2025, and the registration certificate, thereafter all the registration registration ID, even the GST registration, page number 28, is in the name of Sudhir Kumar. हम बता देते हैं, हमारे अगर विक्टिम ने एक कन्फेशनल दिया है, अगर आप पैराग्राफ
विक्टिम का स्टेटमेंट नहीं है, विक्टिम का स्टेटमेंट,
हाँ विक्टिम का स्टेटमेंट है।
इनका कहना स्पेसिफिक है कि होटल के मालिक सुधीर कुमार कभी-कभी होटल आते थे, लेकिन उनके पिताजी रामेश्वर मिलता हूँ जिस पिटिशनर ही कमरा का ताला खोलते थे और कहते थे कि डरने की बात नहीं है, पुलिस कुछ नहीं करता।
ये है हजूर पेज नंबर पैराग्राफ 86 एनेक्चर 6 रामेश्वर महतो
78
पैराग्राफ
is there any connection what is
she has also supported the allegation under 186
yes
for the limit council's appearing on behalf of the parties.
my only submission be noted
आपका सारा सबमिशन
नहीं, एक खाली सिर्फ हम पैराग्राफ 56 नोट करेंगे, और अभी जो नया इन्होंने इन्वेस्टिगेशन किया है इंडिपेंडेंट विटनेस, वो मेरे बारे में क्या कहते हैं वो उतना ही रिलाई करेंगे।
नया इन्वेस्टिगेशन कौन सा
नया चार्जशीट has been submitted below, and now they are proceeding further for further investigation, and now in the further investigation in one independent witness they have examined, he has said, अगर हम पढ़ दें स्वतंत्र साक्षी का बयान 12/12 नया केस डायरी में, कांड अनुसंधान के घटनास्थल यमुना पैलेस पहुंचा, होटल यमुना पैलेस के नजदीक स्थित वाशिंग सेंटर में ओनर से पूछताछ की, उन्होंने अपना नाम मिथिलेश कुमार बताया, पिता रामसेवक प्रसाद चूचू नियर बजरंगबली थाना के आगे बताया गया कि थाना 10 सालों से कार वाशिंग कर रहे हैं, विगत 4-5 वर्षों से यमुना पैलेस होटल के मालिक श्री सुधीर कुमार है, होटल के बगल में छोटा सा गौशाला है जिसकी देखरेख सुधीर कुमार के पिता रामेश्वर महतो करते हैं। दिस इज माय, so that is the statement I admit Millard police has recorded, and because the main accused still has not been arrested, my son, and I have been implicated.
अब कौन सा पैराग्राफ पढ़ें?
और annexure 1 है for annexure 2 two victim statement has recorded manner was supported the case of prosecution.
पढ़िए रेशियो 1 पढ़िए, इनका नाम कहाँ है?
इनका बीच में है होटल के मालिक, नीचे से सातवां लाइन ऊपर से नीचे
होटल के मालिक सुधीर कुमार,
कभी-कभी होटल आते थे, लेकिन उनके पिताजी मतलब रामेश्वर मेहता ही कमरा का ताला खोलते थे और कहते थे कि डरने की बात नहीं, पुलिस कुछ नहीं कर पाती। तो लड़कियों को काम कराता था, प्रति 500 रुपये देते थे, कमरा नंबर से किया गया था, इनकी शादी second victim also same statement, Mama. टोटल 3 victim का जो statement है
तीनों सेम लाइन पर है कि हम बोलते थे व्यक्ति आकर ताला खोलता था, होटल के मालिक सुधीर कुमार का पिता था, बोलते थे कि किसी से डरने की जरूरत नहीं. This is the in line. All the three witnesses, victims have said this.
And you were apprehended on the spot?
On the spot. I was nearby my Gosala, my house was there. When police reached, I also reached to see what had happened. And therefore I was arrested. Still not only one thing, Milord, the similar that co-accused, but said also present, was granted a regular bail. Now charge it.
Statement is come against you.
This is that I have shown Milord what is the statement. The fact is that I am not involved, and the accused who are involved still they are not being apprehended or arrested. Warrant of arrest has been taken. Brief against them, but still they have not been arrested. The fact is this: that, from the case diary also the story has come this. that I was not involved, but only the statement recorded by the victim, 3 witnesses, by the police, I am there. Announced in the other evidence, my lord, I am not come. The hotel owner, I am not the hotel owner. The documents from the document, I am not the hotel owner. The police is saying, my lord, and admitting, yes, I am not the hotel owner. And since they have arrested, they have to show something. Therefore, in the victim statement they have given. In paragraph 56, they are also saying same thing. अब तो अरेस्ट कर लिए थे तो कहीं ना कहीं तो लिखेंगे वो जो पैराग्राफ 56 में लिखते हैं होटल यमुना से संबंधित कागजात लिए होटल का मालिक सुधीर कुमार ही होटल का मालिक है, ये तो लिख रहे हैं यहाँ तक। इसके बाद तो जो चूंकि अब हम वहां पर थे, अरेस्ट कर लिए, तो कहीं ना कहीं तो हमको दिखाना है।
किसी भी स्टेटमेंट में वही खोज रहे इनका नाम आप चेक कर लीजिए, ठीक है, और दिखा दीजिएगा कि बेल रिजेक्ट कर देंगे लिखेगा
नहीं
180 में बोली है, लेकिन 183 में इनका नाम हमको नहीं दिखा, ठीक है। सो पास ओवर करते हैं ये तो सिर्फ एक था, बाकी दोनों विजिटर तो और सीरियस बात है, तो एक अंदर किसी के साथ पकड़ाए हैं, लड़की आपको आइडेंटिफाई की है, ये तीनों केस करेंगे हमसे, थोड़ा उनका स्टेटमेंट देख लीजिए, बाकी सबका भी स्टेटमेंट देखेंगे, इन लोगों का क्या नाम दिया है, 3 कस्टमर आए तो क्या आइडेंटिफाई किया, कस्टमर का कोई आइडेंटिटी है, रूम के साथ कोई टैली है, कौन सी रूम में कौन था, आप देखिए हमको नहीं दिखा इसलिए
नहीं रजिस्टर तो ब्लैंक शो करते हैं पुलिस में, रजिस्टर वाज ब्लैंक देयर, दैट इज द केस ऑफ द प्रोसीजर।
Item 32 PA 5908 of 2026 along with item 33 to 40.
yes जी
इसके डायरिया है मेरे पास, रिसीव नहीं मिल ले रहा है 32 में
32 एक एक करके आप इसके 32 में काउंटर कीजिए, आप बताइए कस्टडी कब से आपका कस्टडी ये नंबर 5908 कौन है आपकी, कोई एंटीसिपेट है, क्या रिकवरी है आपके पास, बस 800 का पेमेंट मतलब किसको पेमेंट करते हैं,
सीडीआर में वो जो रिनकाया है, सीडीआर में लोकेशन जो था वहाँ पर थे, और 800 का ट्रांजैक्शन है वहाँ का जो तो इलीगल इमोरल प्रोस्टिट्यूशन जो चला रहे हैं, ये पैराग्राफ 46 ऑफ केस डायरी
इमोरल क्या है 800 रुपया किसको पेमेंट,
निखत परवीन शिवाजी
देखिए ये नंबर 5908 of 2026 तो हमें ट्रांसफर का petition submits that is in custody since 5/2026 and apart from payment made to one of the victims namely Parveen Nikhar Parveen to the extent of rupees 800, no further material has been collected against the petitioner. The learned counsel for the petitioner responded has submitted that the matter relates to immoral property and the petitioner and Nikhar Parveen is one of the victims. उसका statement record हुआ?
कोई स्टेटमेंट किसी का रिकॉर्ड
स्टेटमेंट तो नहीं आया है।
विक्टिम का स्टेटमेंट नहीं है, किस तरह का केस है? चार्जशीट हो गया?
चार्जशीट नहीं, हमको जो डायरी मिला था उसमें
चार्जशीट नहीं हुआ?
नहीं, मेरा में हमको जो डायरी मिला मेरा में मेरा चार्जशीट इसमें नहीं आया था।
तो फिर क्या करें? आपका तो इनकम्प्लीट का स्टेटमेंट
हाँ,
23 को चार्जशीट
आप कहाँ से बोल रहे हैं? शी इज वन ऑफ द विक्टिम्स।
पारा 46 ऑफ केस है।
विक्टिम नहीं है, एक्यूज है, एक एक्यूज है, विक्टिम पे तो सब एक्यूज है।
हाँ, सब विक्टिम सब एक्यूज है।
इन लोगों का स्टेटमेंट रिकॉर्ड हुआ है सबका 183
किसी का स्टेटमेंट रिकॉर्ड
हुआ है, लिखा हुआ है तो
हम तो नहीं
किसी का स्टेटमेंट नहीं देखना, आपके नहीं देखने से तो आंख बंद करने से तो नहीं ना दुनिया बदल जाएगा। स्टेटमेंट रिकॉर्ड हुआ है
डायरी में नहीं है
तो सभी का है। पैरा 20 में भी 183 का स्टेटमेंट रिकॉर्ड हुआ। कैसे बोल रहे हैं? पैरा 24 में भी
आप पारा 21, 22, 24 विटनेसेस
देखिए पढ़े मत तो ठीक है ना, आपको समझ में नहीं आता। इस कारण से क्या होता है, आप लोग का हर सवाल हर स्टेटमेंट को क्वेश्चन करने लगते हैं, मैच नहीं करता है। 183 का स्टेटमेंट डायरी में लगा। Office is directed to call for the statement of the victims recorded under section 183 from the concerned victims. Was this case on 12th of August? अन्य दिन स्टेटमेंट बिना स्टेटमेंट क्या होगा? जितने भी आपके केसेस में सबका स्टेटमेंट आने आपके पास सलेक्शन इज एब्सोल्युटली मिसमैच। पूरा बैच जब तक स्टेटमेंट नहीं आएगा तो इन लोगों का स्टेटमेंट से हम लोग इन लोग बोलते 183 का बयान ही नहीं दर्ज हुआ।
डायरी में ऐसा लिखा हुआ तो है।
अच्छा जब दिखाई तो दूसरा किसका डायरी लगा दिया क्या? ऐसे
पारा 24 में कुछ और लिखा हुआ
नहीं मेरा रिपोर्ट से डायरी आया।
इतना मोटा डायरी
नहीं दिखाई डायरी कोर्ट का डायरी और आप लोग का डायरी हो सकता है नहीं मैच कर रहा।
वो चेक करें,
ऐसा एक आध बार हो चुका है।
इतना मोटा वो डायरी है जो ओरिजिनल
5901 केस नंबर कौन सा है? 82 कोर्ट का केस नंबर 82 और 26 नहीं
114 2000
दूसरे केस में लोग खराब है
114 2026
पहले वाले केस का इसमें आ गया है। इस केस का डायरी सेकंड हाफ में सारे पेज सुनेंगे उसके बाद ही सेकंड हाफ का होगा। और जिसको नहीं करना है उसने अपने सेंटर आप लोग आ जाइए। इसका डायरी देखिए, इसमें डायरी नहीं आया है।
इसमें 34 में डायरी आया मैक्सी में होगा।
सीरियल 34 में डायरी आया था जरूर है।
इसको में डायरी है
34
इसमें आपको केस डायरी आया है।
फीडबैक जारी है जून तक का डायरी है इस डायरी में एक बार चार्जशीट पर जमा
23 साल
23 साल
अभी आया उस समय तक नहीं आता हमको डायरी जब हम लोग को रिसीव हुआ
Diary is up to the state is council for the teacher has selected that charge sheet has already been submitted in this case on
23/7/2026.
23/7/2026. Take the case ID report from the concerned board with all its examinations. It was taken from period to victim of the recording and certain 183 basis. The same we also forward. और इसमें 11 अगस्त का डेट 11 अगस्त
हम काउंटर फाइल करते हैं